Representative Batista. Representative Bennett. Representative Caldwell.
Present.
Representative Casimiro.
Here.
Representative Cruz.
Present.
Representative Corvese. Here. Representative Dawson.
Here.
Representative Felix. Here. Representative Norrie.
Here.
Representative Place. Representative Roberts.
Present.
Chairman, we have a quorum.
Thank you very much, Madam Clerk. Welcome to the House Committee on Judiciary. We're in the House Lounge. Today is Tuesday, April 4th, 2023, and we have a long agenda tonight. I'm going to start with the bills that are here for consideration. For those of you who are not regulars, that means we're going to vote on them. So the first bill is House Bill 5174, sponsored by Representative Cordovan. It's an act related to Coastal Resource Management Council. It provides a definition of the recognizable high tide line on the public's right and privileges of the shore. Is there a motion for
So
passage?
moved.
Second. It's been moved and seconded. Roll call?
Chairman Craven.
Aye.
First Vice Chair McEntee.
Aye.
Second Vice Chair Knight.
Aye.
Representative Agello.
Aye.
Representative Batista. Aye. Representative Bennett. Aye. Representative Caldwell.
Aye.
Representative Casimiro.
Aye.
Representative Cruz. Aye. Representative Corvese. Aye. Representative Dawson.
Aye.
Representative Felix. Aye. Representative Norrie.
Yes.
Representative Place. Representative Roberts.
Yes.
The ayes have it, Chairman.
Thank you very much. Oh, yeah. Okay, the next bill is House Bill 5438, sponsored by my rep on my right here, Second Vice Chair Knight. It's an act related to courts and civil procedure. Generally, it's causes of action. It permits a signed release to be transmitted to the party responsible for paying the settlement or the attorney by electronic means as opposed to by paper. Is there a motion for passage?
I move passage.
Second.
Roll call?
Chairman Craven.
Aye.
First Vice Chair McEntee.
Aye.
Second Vice Chair Knight.
Yes.
Representative Agello.
Aye.
Representative Batista.
Aye.
Representative Bennett.
Aye.
Representative Caldwell.
Aye.
Representative Casimiro.
Aye.
Representative Cruz.
Aye.
Representative Corvese.
Aye.
Representative Dawson.
Aye.
Representative Felix.
Aye.
Representative Norrie.
Yes.
Representative Place. Representative Roberts.
Yes.
The ayes have it, Chairman.
Thank you. Next bill is House Bill 5780. It comes to us from the Department of Revenue and is sponsored by Representative Alzate. It's an act related to motor vehicles and driving privileges, cards, and permits. It reduces the fee for an original driver privilege card from $50 to $25. Do I hear a motion for passage?
So moved.
Second.
Discussion on the motion.
Yes, Doc.
Very, very quickly. I voted against this bill in its entirety last time. I still disagree with the substance of the bill. I am going to be voting for this because what we have before us really does not relate to the substance of the bill. So I will be voting for the bill. But I stand in opposition to the original content of the bill.
Thank you, Doc. Any other questions? Roll call?
Chairman Craven.
Aye.
First Vice Chair McEntee.
Aye.
Second Vice Chair Knight.
Aye.
Representative Agello.
Aye.
Representative Batista. Representative Bennett. Representative Caldwell.
Aye.
Representative Casimiro.
Aye.
Representative Cruz.
Aye.
Representative Corvese.
Aye.
Representative Dawson.
Aye.
Representative Felix.
Aye.
Representative Norrie.
Yes.
Representative Place. Representative Roberts.
Nay.
The ayes have it, Chairman.
Thank you. Next bill is sponsored by Whip Kazarian. It's an act related to public officers and employees' powers of officers to administer oaths. It adds active magistrates and retired and active justices of the Workmen's Compensation Court to those public officers who can administer oaths within the state of Rhode Island. Is there a motion for passage?
So moved.
Second?
Second.
It's been moved and seconded. Roll call?
Chairman Craven.
Aye.
First Vice Chair McEntee.
Aye.
Second Vice Chair Knight.
Aye.
Representative Agello.
Aye.
Representative Batista. Representative Bennett. Representative Caldwell.
Aye.
Representative Casimiro.
Aye.
Representative Cruz.
Aye.
Representative Corvese. Representative Dawson.
Aye.
Representative Felix.
Aye.
Representative Norrie.
Yes.
Representative Place. Representative Roberts.
Yes.
The ayes have it, Chairman.
Thank you. Next bill is sponsored by Representative Mazakowski. It's also the request of the judiciary. It amends the current requirement of payment of initial filing fee and service of process costs when the victim of crime is still owed restitution at the expiration of the case and seeks to enforce the civil judgment entered at disposition. Is there a motion for passage?
Motion.
Second.
Roll call.
Chairman Craven.
Aye.
First Vice Chair McEntee.
Aye.
Second Vice Chair Knight.
Aye.
Representative Agello.
Aye.
Representative Batista. Representative Bennett. Representative Caldwell.
Aye.
Representative Casimiro.
Aye.
Representative Cruz.
Aye.
Representative Corvese. Representative Dawson.
Aye.
Representative Felix. Representative Norrie.
Yes.
Representative Place. Representative Roberts.
Yes.
The ayes have it, Chairman.
Okay, bill passes. Next bill, House Bill 6029. It's the request of the judiciary and sponsored by Chairman Corvese. It's an act related to criminal offenses, false impersonation, provides the state court clerks to add to the list of public officers for whom falsely assuming their identity would be a criminal offense. Is there a motion for passage?
So moved.
Second.
Moved and seconded. Roll call.
Chairman Craven.
Aye.
First Vice Chair McEntee.
Aye.
Second Vice Chair Knight.
Aye.
Representative Agello.
Aye.
Representative Batista.
Aye.
Representative Bennett.
Aye.
Representative Caldwell.
Aye.
Representative Casimiro.
Aye.
Representative Cruz.
Aye.
Representative Corvese.
Aye.
Representative Dawson.
Aye.
Representative Felix.
Aye.
Representative Norrie.
Yes.
Representative Place. Representative Roberts.
Yes.
The ayes have it, Chairman.
Thank you very much. Okay, now we go to the hearing portion of our calendar tonight. And as we have done since we started here back in January, I've been requested, and I think it's a great idea, to read what it is that we do now. Because I'm going to read this, and then I'm going to ask for a motion to hold all bills for further study. This is what that means. Before the committee starts hearing testimony on the bills on tonight's agenda, I'm going to ask for a motion to hold the bills for further study. I'd like to remind the committee that a vote in favor of holding all bills for further study is not substantive and does not signify any position on the merits of the bill. This motion is procedural only and simply allows the committee sufficient time to review both verbal and written testimony and to organize the hearing process. That's why we actually have that staff over there with lawyers who take notes so that we can consult them before we come back with a product that is being requested to vote on. So with no further ado, I have one bill, a couple of bills actually, that
I move we hold all bills for further
yeah.
study.
Second.
been moved and seconded. All those in favor signify by saying aye.
Aye.
Opposed, nay. Okay, the next thing I want to do is, we have a lot of bills tonight, by the way, so I'm going to make some suggestions. I'm going to put all bills in play. I'm going to ask, by doing that, I'm going to ask the sponsors to come forward and to make a presentation to you, brief as they can, because of the number of bills, over 30 of them we have tonight. And then they can leave, in some instances, go to other committees where they have other bills, or maybe they're chairing that committee. So the first one I want to deal with tonight is House Bill 6181, sponsored by Representative Batista. It's an act related to state affairs and government, law enforcement officer screening, discipline, and decertification. It creates an officer discipline board and provides law enforcement personnel to comply with this act. Just so that you know, the reason we're doing this, we have a lobbyist and an expert on this, that one has to get an operation tomorrow and the other has to catch a plane by 6:30 at TF Green Airport. So, Jose.
And, sorry, just to be clear, just 6181 only at this moment, right?
Yes.
Okay, 6181, otherwise known as Law Enforcement Officer Screening, Discipline, and Decertification. This is a bill that is focused on what we call a POST board, which stands for Police Officer Standards and Training. My understanding after working with and talking to the Rhode Island Chiefs Association is that there exists some version of a POST board now. What this bill would help do is codify what the post is, who makes it up. There would be 15 positions on this task force, 7 of which would be made by police officers, 7 would be civilian, and 1 attorney general. And the purpose of having this board, the post board, is to make sure there is consistency throughout the state for police officers as far as their training, as far as screening, as far as discipline. And so we've seen a lot of examples in which we'll have an incident in one part of the state, and that police officer may or may not be reprimanded. They're going to go work in another part of the state. And so this bill, if I could reduce it to one word, would be consistency throughout the entirety of the state.
Any questions for the sponsor? Seeing none, Lenny, you come forward, both of you. Welcome. Len, do you want to go first and then introduce your expert?
Sure. Thank you, Chairman, members of the committee. My name is Leonard Lopes. I'm with...
Is that, I
can
don't
you hear
think it's
me?
on.
It's red. Maybe I'll speak a little louder. There we go. Thank you, Chairman, members of the committee. My name is Leonard Lopes, and I'm here with Seema Sadanadan, but I may have just butchered her name, so she will say it again on this very important piece of legislation. I want to also thank Representative Batista for his leadership on this issue. I know we spoke to several people in this room about this bill, and we're going to submit and work with those folks and work through some language on the bill in the coming weeks ahead. But I just wanted to thank, first and foremost, you, Representative, for your leadership on this issue, and look forward to members of the committee to talk about this bill. So with that, I'm going to turn it over to Seema, who's the expert in this area, and she can take it from here.
Welcome.
Hey,
Thank
before
you
we do
so
that,
much.
Mr. Lopes, are you testifying in favor or against?
Sorry. Strongly in favor.
All right.
Thank you for the clarification.
Thank you, Chairman Craven, members of the committee, and to Representative Batista for your leadership on this issue. My name is Seema Sadhanandan. I'm an attorney, and I'm here on behalf of Arnold Ventures. Arnold Ventures is a philanthropic organization that advances data-driven policy to make communities in America safer. We are among the largest criminal justice reform funders in the country. We are here today to testify in strong support of HB 6181. And what 6181 would do is it would expand the authority of the post, a state agency, so that it could both certify and, in instances of sustained serious misconduct by a law enforcement officer, decertify a law enforcement officer. We at Arnold Ventures are particularly sensitive and supportive to what law enforcement in Rhode Island and in this country do for our community. Our communities place a tremendous amount of trust in law enforcement, and we ask law enforcement to enter into difficult situations, into emergencies, to walk straight into crisis, and sometimes dangerous situations. We believe that 6181 will improve policing and public confidence in law enforcement. Before I discuss 6181, I want to acknowledge that much of this evening's discussion will be on LEOBOR. And Arnold Ventures strongly supports a reform to LEOBOR. In fact, Rhode Island is the only state in New England that has a law enforcement Bill of Rights. Most states in the country do not have a law enforcement Bill of Rights. We support removing any special protections that make it difficult, if not impossible, for chiefs to discipline officers in the case of serious misconduct. So the debate about LEOBOR really outlines fair discipline in the context of a local law enforcement agency. But 6181 offers a process that is related but separate. It's a process for a state agency to certify and in certain circumstances to revoke a certification of a law enforcement officer. In most states around the country, the post has this authority. Right now, it is my understanding, and based on some of the conversations that we've had, that Rhode Island chiefs, by a matter of policy, do collaborate in instances where there is a finding of serious misconduct and share information. And we believe that process should be codified within a state agency, a process that is uniform and fair to engender public trust. Ultimately, public safety is a partnership. It's a partnership between law enforcement and communities and absolutely requires mutual trust. Other similarly situated public sector employees like nurses and teachers also have a statewide certification regime that's separate from their employer discipline process. In the legal profession, for example, if you are a lawyer and you work at a firm and say you embezzle funds from a client, your employer can suspend you or fire you, but the state bar can revoke your actual license. Every single state in the entire country has a decertification regime, with the exception of Rhode Island and Hawaii. In each of these states, there's a statewide agency that's authorized to both certify and to revoke certification in certain cases. Decertification, as a process laid out, is protective of due process. And in New Jersey, when they moved to authorize the post to have the authority to decertify, it was supported by the largest law enforcement union in the state, the State Troopers Association. And the president of that union made a statement in support and said that this decertification regime was common sense reform. We believe that 6181 is both common sense and long overdue. Thank you so much for this time and for accommodating us, and welcome any questions you might have.
Any questions for the witness? Seeing none, thank you.
Thank you.
Good luck. Is Grace here? Grace? Grace, her bill. Oh. Let's see. Ray, let me do yours now, if you don't mind. While we wait for Grace. Grace, up. You ready? Okay.
There she is.
Good afternoon, Mr. Chairman and members of the Judiciary Committee. The House Bill 5562 is a bill that will help prisoners, inmates, to reduce sentence by accumulated time, and the accumulation of the time will be helping them to get released a little bit early. It's a simple bill. If they participate in program, if they do the right thing, they will be granted to reduction of the sentence. That's all the bill about it. So thank you, Mr. Chairman.
Any questions for the sponsor? Okay, we'll move on to the next bill we're putting in play. Where did Ray go? Is Deputy Speaker Ray Hull here? I guess not. All right. Jay, you want to come up? Ray, come on up. That's fine. You can both sit there. Deputy Speaker Hull, you want to put your bill into play?
Thank you.
It's
Mr.
House Bill 5888.
5888. Thank you, Mr. Chairman, and thank you, members of the committee. LEOBOR. Difficult thing to really speak about, but it's not really when you think about it. The Law Enforcement Bill of Rights became statutory in the concept in around 1970 after legislation was introduced in the U.S. House of Representatives. The intent was to create the framework that balances the constitutional due process rights of officers as employees within the rights of the citizens. In 1974, Florida, Maryland became the first states to codify their version of LEOBOR in their representative states. Rhode Island became the third state to adopt LEOBOR. Approximately a dozen other states followed suit through the 1980s and 1990s. Since adoption of the Law Enforcement Bill of Rights, it has been amended several times. Most of the amendments have been slight in nature, but LEOBOR was simultaneously reviewed, amended on occasions. In 1995, the Rhode Island Senate and the House of Representatives appointed a special legislation commission based on recommendations in 3 issues: promoting efficiency in the LEOBOR process, protected management rights, and limited the cost, and determine the court's role in the process and increase transparency. Somewhere around in 2020, the Senate established a special commission. And the Senate commission was established to look at LEOBOR. It was chaired by Senator Metz, and members of the committee introduced themselves. Michael Avora, Executive Director of Rhode Island Commission of Human Rights, the Reverend Howard Jenkins, President of the Ministers Alliance, Tony Capezza, Director of International Brotherhood of Police Officers, Cynthia Coyne, District 32, Barrington, Jose Batista, Executive Director of Providence Eternal Review Authority, Jim Vincent of the Providence NAACP, and Harold Metz. The proposed task force shall be to make comprehensive studies and provide recommendations to law enforcement's Bill of Rights. Brings us to where we're at now, 5888, and the reform process that are needed in the changes. The changes in this bill, in the committee, changes the members from 3 members to 5 members. 1 member appointed by the Chief Justice of the Superior Court, who shall be retired judge, justice, or judge of the Supreme Court, or the Superior Court, or district. 1 member who should be the Executive Director of the Human Rights Commission, or designee. 3 members who shall be active or retired law enforcement officers within the state of Rhode Island. The retired justice or judge appointed by the Chief Justice of the Superior Court shall serve as chairperson of the hearing in committee. It strips the provision in the law that prohibits public statements being made. The bill changes to noting that this chapter shall constitute as a prohibiting a chief or designee from making public statements or concerning an incident or matters of public interest involving any law enforcement officer employed by the chief's law enforcement agency. Public statements shall be made in the sole discretion of the chief. Noting that this chapter shall be construed to prohibit a law enforcement officer from making any public statements himself. Within 5 days of changing the law enforcement officer's agency receipt, the officer shall request a hearing. A law enforcement agency shall petition the Chief Justice of the Superior Court to appoint a justice or judge to the hearing committee. Law enforcement agency shall notify the Executive Director of the Human Rights Commission, requesting that they confirm his or her willingness to serve on the hearing committee within 5 days of receipt of the agency. It strips the provision that requires police chiefs associations in the Fraternal Order of Police and International Brotherhood to provide a list of possible law enforcement officers to serve as chair and hearing committee. Department rules and regulations go from 2 days to 14 days. Minor violations go from department changes from 2 to 14 days. As an active law enforcement officer in the city of Providence for the past 35 years, I have a new position on this bill. Being an active black law enforcement officer makes my view more unique. Times have changed, and the dark underbelly of bad law enforcement officers is now being constantly exposed to light. Because of this change in our society, updates to the decade-old law must be made in order to ensure transparency, accountability for bad actions, conduct by law enforcement officers. When I say the vast majority of officers I served with over my 30-year career are honorable individuals with the sole purpose and dedication to protecting the lives of the people in the city of Providence. But any barrel of apples, there were a few rotten ones. This is why the bill needs to be changed. One last thing. The recommendations that I put forward into this bill come directly from the task force that was put together through the Senate with the people's voice asking for some change in LEOBOR, the Law Enforcement Bill of Rights. So it's just something not made up. And they came to the conclusion with these recommendations, and that's why they're forward in this bill now. I thank you for your time and your consideration.
Any questions for the sponsor? As you know, we've got a lot of people testifying on these bills. We'll be dealing with them afterwards. We'll be dealing with them afterwards, one by one. So we're going to put all of the LEOBOR bills in play. So let me get to Representative Edwards, 5149. It's an act that would abolish penalty of life without parole and amends, repeals all sections of the general law relating to prisoners serving a sentence of life without parole. It would have retrospective effect for any offense committed after January 1, 1991.
Thank you, Chairman, members of the committee. What this bill would do would allow people who are sentenced to life with the possibility of parole in the state of Rhode Island to have a conversation with the parole board after serving 25 years in prison. This is not going to be the most popular bill you ever hear, nor the most popular bill I ever introduce. I have heard from the critics. I have also heard from the families of the victims. And I will say that they were, of all the people who called me and spoke with me, they were the most sincere, they were the most polite, and while they never will agree with me on this issue, they did understand. Life without the possibility of parole is effectively the death penalty. There is no date certain, but they do not have the same rights as someone who is convicted and sentenced to death in other states. Every state in the United States, with the exception of Alaska, has either the death penalty and/or life without the possibility of parole as a sentencing option. I heard the families that I spoke with, and I have, after my conversations with them, decided to amend this legislation accordingly to allow only two criteria to actually have the conversation with the parole board. The first was the easiest. Those prisoners who are actually in end-of-life situations. Right now in the House Finance, we will be hearing the governor's bill to allow for them not to have guards, and if they're in an actual end-of-life situation, that they can be out of the prison, because if they're dying and they're not able to get around, there's no reason to guard them. The other classification of prisoners who would be eligible would be those who committed their crimes prior to their 25th birthday, because they actually had diminished culpability. There are, right now, 29 men. All of them are men, and they committed murders. Every single one committed a murder. You don't get life without the possibility of parole unless you commit a murder with aggravated circumstances. With the 10 men who would be actually eligible to have a conversation with the parole board, we are also going to exclude those whose crimes included aggravated sex offenses. They will not be included. They're precluded from this legislation. They will serve out their terms just like the other 19 men. The bill will be prospective, not retroactive, except for those two classes. So going forward, judges can give people multiple 50-year life sentences to be served consecutively and be affecting life without parole in another way. But those prisoners would also have the ability to have a conversation with the parole board after 25 years, after full 25 years of service. The parole board in Rhode Island, as anyone who's ever dealt with them, I fortunately have not, they are one of the tougher parole boards in the country. They can listen to you and tell you to come back in 5 years or come back in 10 years. Just send you away. They do not let people off who deserve to be in prison, who truly haven't become rehabilitated. The only ones that they would probably parole under this legislation from the existing group would be those in end-of-life situations. The parole board is anything but easy, and they're not foolish, and they understand the people they're dealing with. That concludes my testimony, Mr. Chairman.
Any questions for Representative Edwards? Seeing none? Okay, gentlemen, thanks. Both
Thank you very
bills are in
much,
play.
Chairman, members of the committee.
Representative Lombardi? You've got three bills. No, I've got 5110, 5115, and 56. No, I'm sorry.
That's it.
Oh, you're the last guy. Yeah, I thought you. I'm looking at my mistake.
Am I on, Mr. Chairman?
You're on.
Oh, thank you. Thank you, Mr. Chairman, members of this board that I think does your person's work, and I know every day you're going to hear these heart-wrenching stories, but I think, I hate to be redundant, but I'm sorry. Are we starting with 510, Mr. Chairman? 5110, is that the one?
5110.
Okay, so this is a First Step Act, and what this does, Mr. Chairman and members of the committee, it's fairly self-explanatory. This act would establish Rhode Island's First Step program requiring the Department of Corrections to assist offenders with reintegration into society, provide them with counseling, medical care, and education, and provide for modification of imprisonment or relocation to pre-release confinement for elderly and terminally ill offenders. I guess it kind of dovetails with what Edwards was talking about, but and you know you've arrived, Mr. Chair, members of the committee, when you have our colleague Joe Almeida, Jim Vincent from the NAACP, Cedric Huntley, and some other gentlemen and ladies that you'll be hearing. Some have been affected directly because in many instances, there are no programs. You know, you went to the prison system, and sometimes you come out a lot worse than when you went in. In some instances, men and women often come out sometimes with drug habits, for example, so certainly psychological issues and so on and so forth. I think we owe a duty in some instances to people that are reentering our society and the communities rather, to provide, making sure that they're getting the counseling, making sure that they're getting the medical care, making sure that they have educational opportunities, and basically change what's happening. Because in many instances, Mr. Chair, members of the committee, you know, you're taken from the environment. So let's take Southside. Within a 12-block radius, I think you have 55 to 60% of the social service programs for the entire state. Guess what? They don't get 60% of the money. And what you're doing is you're concentrating all those issues in that one area. So I guess what I'm saying, Mr. Chair, is when you leave prison, they don't say, okay, you're going to do your rehabilitation in the Hamptons. That's not what happens. You usually go back to where you were living, interacting with the same men and women that you interacted with before, and there's really no break. So I think this gives those ladies and men an opportunity to maybe change their way of thinking. And I can tell you this, for someone who has kind of experienced it, not only with family members, but also in my own lifetime, sometimes you got to change the mentality, you got to change the way you're thinking, and you got to break that cycle. But I'll tell you what, if you're going from one environment where, you know, your life's on the line every day, you don't know what's going to happen to you. You don't know if you're going to get shanked. You don't know if you're going to get whatever it is that you're going to get. And then you're going to go on the street, and guess what? Sometimes it's twice as tough on the street. And I think some of the people who are going to testify can speak way more eloquently than I can about that stuff. Way more eloquently. So it's just, it's about taking a positive and a positive step and not discarding people just because they have prison time over the head or they've done some time. And I'll leave it at that, Mr. Chair, members of the committee, and I will endeavor to try and explain, but I can tell you this here. I think that some of you will understand by practicing law some of the other things that have happened in your lifetime, but certainly some of the other speakers can speak way more eloquently than I can.
Any questions to the sponsor? Okay, 5115.
Thank you. Mr. Chair, members of the committee, last year there wasn't a dry eye in the room when I presented this, well, except for those that don't believe in it, but there's a thing called expungement. And, you know, there was a reference earlier about, you know, being less than 25 years old, you know, you're 18 years old, you're 17 years old, you're charged as a felon, you know, maybe felony larceny, and then maybe 2 years after that, you know, you, I don't know, you steal a car, and then you do something else, and guess what? You're 23 years old, and you will be forever defined by that. Forever. I can tell you this. When I had my little thing with the police, I was 1 month over 18. And guess what? I'm going to be 71. Sometimes people still try to define me. But you know what? I'm too damn bullheaded. I won't allow them to do it, Mr. Chair. But I can imagine that if I didn't have the opportunities he's presented, and by the way, my case was an acquittal. And this body had to actually change the law to allow me to expunge or seal and destroy that record. The funny thing with the FBI, you could never expunge it, whether you're acquitted or not. But that's another issue for another day. But what this does is it affords somebody an opportunity that when they're 17, 18, 19, 20, they're charged as an adult, that they will be able to get these felonious, and again, excluded in here just in case for those that are not understanding. This has to coincide with the expungement statute. So if it's a crime of violence, you know what, they are excluded. Those crimes are not included in here. Okay, it states it right in the statute. But for those that are on the cusp and those that they had a bad childhood, you know, they were alcoholics, they were drug addicts, they were molested as children, whatever the issue is, and those are not excuses, those are real things that happen to real people, that they will be afforded an opportunity to do this. Now, why? Why? Because guess what? It affects your ability to get housing. It affects your ability to get a job. But the one that's most heart-wrenching at me, and I was never fortunate enough to have children, in many instances, you cannot participate in your children's programs. Whatever it may be, you may be excluded from that. Now, just think about that for a minute. I've had, just this week, I had a couple of gentlemen, and one lady was asking me. In fact, I was helping someone in the State House whose friend had some issues, and they wanted to know if they could get their record expunged. And the person was very candid. They said, I was an alcoholic, I was a drug addict. That is not me. I work hard, I have a business, I'm doing what I got to do, and I am forever being defined by this. Can't do it. Can't do it. And I wish I could. A lady, basically the same thing. You know, she was drugs, alcohol, prostitution, and a whole bunch of other things. And guess what? Can't do it. Now, I know last year a lot of people said they wanted to support it. If you truly want to support this bill, now's the time to do it. We can't wait. This needs to get done. I don't know what else to do. I know many of you were like tearing up last year, and you had that gentleman, speak, and I don't know if Ramon's here. I hope he is one of the speakers, but we have to get this done. There are many people falling by the wayside here. Afford them an opportunity. Give them a chance. Why not? Guess what? And maybe, maybe the thing that I need to add is maybe we create a panel with a police officer, a prosecutor, a retired judge, a social worker, an inmate, and something else. But let's do something. I don't have to sponsor the bill. Somebody else take the credit. I'm not looking for credit. I just want to do something. And I think you can't imagine how many people this would affect, especially in the inner cities, people, the lowest social stratification, and mainly people of color, brown, black, yellow. So with that, I will try to answer the questions, Mr. Chair, members of the committee, but I think you're going to be very enchanted and excited about, hopefully, in a positive way, from the people that will be speaking after me. I'm going to be the worst speaker. They're going to be the better speakers, because some of them are going to tell you some heartwarming things, and I hope one in particular tells about he may have had to get a restraining order against the police department. That's how much they were harassing him. But that's another issue for another day. That's up to him if he wants to say that. Thank you, Mr. Chair, members of the committee. I appreciate it.
Any questions for the sponsor? Thanks, John. Oh, you got one? Oh, I'm sorry.
Thank you, Chairman. I just had one question, please. So on the first page, line 19, it says, any person who has been convicted of more than one felony and who has not been convicted of a felony which is considered a crime of violence. So I know what I perceive to be a crime of violence, but do you have an actual definition of what exactly is meant by that?
Crime of violence?
Which types of crime?
Yeah.
So, because I'm looking more specifically, I'm kind of curious about sex offenses. That's why I'm asking.
It's right in the statute. The definition is right in the statute of those, what that means.
Okay.
So if murder, you can't do, right? So on and so forth, yeah.
Okay, so would this bill have more
It's whatever's in
leniency?
the statute.
Okay, I don't know what's in this. Do you know what's in the statute?
Yeah.
I'm sorry, I can't hear you.
Yes.
For the benefit of the room, the crime of violence is, which would be excluded from all expungement, is murder, manslaughter, first-degree arson, kidnapping with intent to extort, robbery, larceny from the person, first-degree sexual assault, second-degree sexual assault, first and second-degree child molestation, assault with intent to murder, assault with intent to rob, assault with intent to commit first-degree sexual assault, burglary, B&E with intent to commit murder, robbery, sexual assault, or larceny.
Thank you,
the
Representative.
list.
Yeah.
Thank you.
Yeah, it's all the crimes that are as elicited in the statute. So
Okay.
we're not doing any, we're not changing that.
Okay.
We're just affording people that, you may have had a bad childhood. I mean, who amongst us?
Yeah.
I'm
thank you.
guilty.
Yep. Thank
I'm
you.
guilty. I've probably been arrested more than everyone in this room put together, but anyway, thank you. I appreciate it.
Thank you. Okay, the next bill is Representative Stewart. Are you ready? Okay. Do you want to get those two witnesses? Okay, then I'll bring up Representative Morales. Yes. Oh, we've got a couple of new members here that weren't counted, Madam Clerk. Oh, okay. Okay. We voted on 6 bills. Do you want to?
Yeah, thank you, Mr. Chairman. To make it simple, Madam Clerk, the only one I'll be voting no on is 5780. The remainder are yes, and then again, no on hold for the bills for further study. Yep. So 5780 is the only one I'm a no on. Thank you.
Floor's yours. Take them in
Thank
the
you so
order
much,
you
Mr.
wish.
Chair, for the opportunity to discuss and consider House Bill 6071, which has now been introduced for the 3rd consecutive year as it relates to limiting local and state law enforcement from using artificial intelligence that is armed with a weapon. Such specific examples include drones equipped with firearms, quadcopters armed with explosive devices, and lethal autonomous weapon systems. Now, unfortunately, these examples of armed artificial intelligence are not works of fiction, nor can they only be found in movies. Instead, they are currently being used actively within the militaries of various nations, including the United States. So in other words, these are literal weapons of war. Weapons of war with no traces of accountability, given the fact that, again, they are ran by artificial intelligence. As you will note, though, there is a limited exception to this bill as it relates to situations where an armed robot is needed to mitigate an explosive-related incident or to breach a barricade, as noted on subsection B within page 2 of the bill, based on the recommendation of our state's fire marshal, whom I've worked on this bill with since last year's testimony. Now, unfortunately, artificial intelligence continues to have a growing presence across police departments in the United States, specifically robot dogs and drones. Thankfully, this artificial intelligence currently remains unarmed. Nevertheless, I am deeply concerned and have reason to believe that we are going to reach a day in the very near future when local police departments and/or correction agencies decide to adopt a practice of arming artificial intelligence with weapons or using them in a physical manner against civilians or inmates. That is why it is necessary that we establish specific and common sense policies now. Therefore, this bill is proactive, a preventative measure to ensure that our local and state police departments are never in a position to use drones, robot dogs, or other forms of artificial intelligence that are equipped with weapons, because the presence of this dystopian technology would create serious safety concerns across our communities. It would open up the risk of miscalculated civilian death, further militarize our police and correction officers, while prompting a legal gray area as it relates to accountability. After all, who is going to be held accountable if artificial intelligence accidentally kills a civilian or an inmate? Is it going to be the operator of the autonomous intelligence machine? Again, this is a legal gray area, which is why it is better that we restrict the use of them now. Now, in terms of the federal precedent set for the use of artificial intelligence technology by law enforcement, the Obama administration had previously placed limitations on the types of equipment that police departments can obtain, including robot police dog models, and specifically any artificial intelligence that would otherwise be armed with a weapon. Most recently, however, back in 2019, the Trump administration reversed them, which makes legislation like this so much more important. So overall, this legislation is a preventative measure to ensure that our state does not have to experience the fear or the uncertainty of police militarization fueled by public tax dollars. And as I close, I just want to be very clear. The development of technology moves a lot quicker than legislation and policy. So if we do not act, Rhode Island could become home to armed artificial intelligence due to a lack of enacted policies and forethought, similar to what we have seen in New York City and cities across Massachusetts, where they started deploying pilot programs and were met with community resistance, which then resulted in the respective police departments returning the respective police dogs that they had received from Boston Dynamics. I also want to note that we did have some letters of opposition, and we had folks sign up in opposition as well, specifically from the Department of Corrections and some respective police unions, which, to be fully transparent, I am a little confused about, because in previous years they had never submitted testimony in opposition to this bill before, because again, this is simply just stating, if you are going to use artificial intelligence, it cannot be armed. And so I would encourage you to read through some of the testimony that was submitted, because I did find the language to be somewhat alarming. I don't want us to ever be, again, in a position where within our prison system, we have artificial intelligence that is armed. I don't see a use for that, because any time artificial intelligence which is armed is ever used, it is used for the purpose of warfare. We cannot and must not normalize this idea that regardless of whether we're looking at local, state, police departments, or corrections agencies, should they have the discretion or the ability to access, again, artificial intelligence armed with weapons. Thank you.
Any questions for the sponsor? I don't see any. Thank you. Again, we'll get to those witnesses. Now, Representative Stewart, can you come forward? And then I'll ask, I think you have 3 witnesses with you? We've only got 3 chairs. If there are 2, you can bring them up. We'll figure it out. Sure, yeah. The victims. This is another, this is Representative Stewart's bill, 5567. It repeals or calls for repealment of the Law Enforcement's Bill of Rights.
Great.
Floor is yours.
Thank you so much. Thank you, Chairman Craven, members of the Judiciary Committee, for the opportunity to speak about House Bill 5567, which, as you heard, seeks full repeal of the Law Enforcement Officers' Bill of Rights, popularly known as LEOBOR. This repeal bill is not anti-law enforcement. In fact, my own father retired from the Chicago Police Department, where he was an officer. I understand policing is a difficult job. Instead, this repeal bill is pro-rule of law. I'd like to share a bit about why that matters to me. Outside of this role in the State House that I began this year, I teach teenagers U.S. history and political science. I have done so for over 20 years because I care about democracy and that we work to realize its aspirational principles, which include rule of law. Where there is rule of law, nobody is above the law, all are subject equally to the law, and there is transparency. Enacting rule of law helps to foster the public's trust in institutions, especially those associated with government and the legal system. I'm afraid that since 1976, the existence of LEOBOR has undermined rule of law here in Rhode Island, and with it undermines trust in legislators like us, in the police, and in the state's judicial system. Currently, Rhode Island is one of 13 states that have some form of LEOBOR. That means that the majority of states in the U.S. do not have it. These states have been able to function and maintain police. Somehow, 37 other states have concluded that standard due process is sufficient. Rhode Island's LEOBOR insulates police more than most through a variety of measures like the LEOBOR hearing panel and who gets to decide who is on it, and the provision of full pay and benefits while the hearing process plays out. Some of my colleagues will argue tonight for LEOBOR reform, and I suppose that would be better than where we are right now. I want to point out, though, that reform will not address the fundamental problems that LEOBOR creates because it sets apart a group of people for special treatment subject to special rules that are opaque to the public. Some might argue that LEOBOR is justified because the nature of policing is difficult and uncertain. Unfortunately, in the U.S., in 2023, with increased frequency, many now face difficult workplace situations in which they can no longer count on making it home to their families at the end of the day. None except police officers enjoy their own Bill of Rights in our state law. Firefighters don't have their own Bill of Rights. Doctors and nurses have no Bill of Rights. Teachers do not enjoy our own Bill of Rights, nor do our students. Instead, we only have a Bill of Rights that is in the U.S. Constitution. And if we are accused of misconduct or doing harm, we lose our jobs and maybe can contest it through a wrongful termination lawsuit. As long as the state of Rhode Island continues to say that one group is entitled to a special set of rules, the state perpetuates inequality, abandons transparency, sidesteps simplicity and being clear, and promotes distrust. You'll hear from several people tonight about the harm that LEOBOR perpetuates because it makes difficult to discipline, in other words, hold accountable officers who are involved in serious cases of misconduct or crimes. And so I'll just conclude my remarks there by saying that I hope we'll finally have the courage to repeal LEOBOR, just like Maryland did a couple of years ago. So thank you.
Okay, any questions for the sponsor? Seeing none. Now, both of you would wish to testify. I made an accommodation because I know there are some circumstances under which you feel uncomfortable being here. But I can't treat you any differently than any of the other witnesses. So I'd ask you to keep your testimony to 2 minutes each. Okay?
I'm also reading for my son that could not be here. This is overwhelming for him, the victim.
Well, you can...
One page for him and mine.
Okay. All right.
Thank you. I'm Lisa Vincent, Dominic Vincent's mother, and I'm reading this for Dominic tonight. He asked me to, but he did write up his views on LEOBOR. To the Judiciary Committee, my name is Dominic Vincent. I stand for repeal Bill 5567 or a reform bill 5888 or 5567 for the Officers' Bill of Rights in Rhode Island. Ideally, a repeal would ensure the safety of Rhode Islanders, but a reform bill would be a step in the right direction as well. My family and I have personally been impacted to an unimaginable degree by the excess use of force of law enforcement, specifically Officer Daniel Dolan. Use of a deadly weapon to have a fatherly chat, in quotes, with me on the night of June 23rd, 2021. According to Dolan, speeding was enough to warrant a discharge of a firearm. The incident shows the poor judgment officers of the law may have at times. While some officers truly protect and serve, as they should, we must not protect those who endanger innocent lives. Police officers who conduct themselves with the safety of their communities in mind do not have to worry about a potential change to LEOBOR, as they do not put themselves in situations where they need the protections of LEOBOR. I would have liked to present my opinions in person. However, the emotional toll of speaking in front of so many individuals regarding my nearly fatal interaction with Officer Dolan is too much for me to handle currently. I want to personally thank all of the representatives who have proposed change to LEOBOR.
Ma'am, time's up.
I have one sentence left.
Okay, go ahead.
Thank you. As they have the well-being of the community at the forefront of their policy making. Sincerely, Dominic J. Vincent.
Okay, thank you.
Thank you.
Good evening. My name is Leslie Seepy. I reside in Warwick, Rhode Island. Okay, can you hear me? I'm the proud aunt of Dominic Vincent. In favor of the three bills, 5888, 5667, and 6200, although I would like a full repeal. And I will tell you why. I do thank you for the opportunity to speak with you today, and thank you for hearing me. Our entire family has been gravely affected. On the evening of June 21st, 23rd, 2021, I was pulling into my driveway at home, ready to retire for the evening, and I received a phone call from my 78-year-old mother, Dominic's grandmother. There's a family emergency. Dominic has been shot. I thought, my God, how can this be? This young man is an amazing young man. Okay, so what happens is, my nephew, during the evening hours of June 23rd, 2021, pulled into Wicked Good Pizza on Route 3 in West Greenwich to pick up a Meat Lover's Pizza. You see, Dominic was unaware he was chased down by an enraged, out of control, off-duty policeman. Instead, my nephew didn't get his pizza. What he got is he got a gunshot wound. Daniel Dolan, enraged and out of control, off-duty policeman, terrorized my nephew. Daniel Dolan shot an unarmed 18-year-old young man, my nephew, Dominic Vincent. As I sit here before you today and choose words to describe how my nephew has been gravely affected by the irresponsible actions of Daniel Dolan, the words cannot express the deep emotional wounds Dominic has to live with day to day in addition to his gunshot wounds. Dominic now lives with PTSD, post-traumatic stress disorder, a high level of anxiety which affects him emotionally and physically. His life has been gravely and negatively affected. He is in counseling. Dominic's mom, my sister, has constant nightmares and a high level of daily anxiety. She is in counseling as well. My brother-in-law, as well, experiences a high level of anxiety, and he is in counseling. The ripple effects, being terrorized by a law enforcement officer, someone who is supposed to protect citizens, can't be adequately described. I'm almost done.
Thank you.
The police officer terrorized a child and now gets to sit home and collect his back pay of $120,000. It's not right. It's not fair, and it's causing my family indescribable anguish and emotional pain. I'm not an expert on the bill, but what I do know, as the law stands now, you are allowing, as it stands now, policemen or policewomen who are being reprimanded for grievous behavior and actions that need punishment to have a choice to work a solution in their favor. They get to choose who will have a voice in their punishment.
Ma'am.
Favorable to the police and unfavorable to the victims and the citizens of Rhode Island. Change is sorely needed. What is the solution, and how do we solve this problem?
Ma'am.
Either completely get rid of LEOBOR or drastically reform it now. You are the representatives. I have a voice today. I know there's a minute and a half, but we are suffering gravely.
I know.
You've had over 2 years to make change, and nothing has gotten done. And how long will you allow police protection that exists, right? And just imagine this. If you representatives take action to make changes to this bill immediately, you will be a healing balm to the actions, to the past victims and their families. Almost done. Today, I am asking you, I am pleading with you to take action of reform or completely dissolve LEOBOR, the Office of Bill of Rights. Take action on behalf of the 70,000 citizens in the state of Rhode Island that each of you represent. And I am asking you to please have mercy on my nephew and the victims. Hear their cry today.
I have to ask you to terminate.
I'm done. I'm done.
Thank you.
I'm done.
Thank you very much.
Okay? My nephew,
Harrison,
okay? I'm done.
Harrison.
I read my son's.
Oh, okay. Harrison, I'm not going to ask you to testify right now. You're testifying on several bills, and I want to have you testify all at the same time, okay? Thank you. But I'm not taking, this was just an accommodation. I promise you, you'll be getting it, you're getting your opportunity to testify shortly. You want to read your own testimony
Yes.
now. Could you please keep it to 2 minutes, okay?
I will try. I've had to be quiet for almost 2 years.
I can't extend it any longer. I don't want to do that. Just Tell us what you want us to do. That's what I'm asking you. This committee wants you to tell us what you want us to do.
Get rid of it. Get rid of it.
You need to repeal LEOBOR, but I'm going to tell you what we've been through. Why can't I have my 2 minutes?
Go ahead, speak.
You can have 2 minutes, but I'm going to cut you off. I can't do it. We'll be here till...
Dolan keeps getting all the... And I have 2 minutes. Okay, here we go. Set the timer. I am Lisa Vincent of West Greenwich. Thank you for the opportunity to speak today. I am the proud mother of Dominic Vincent, who was shot by Daniel Dolan, who repeatedly has a horrible history. He thinks he is above the law. He hides behind his badge. He is a coward. What my son experiences from being shot by Daniel Dolan, who has a long history and has been protected. Nightmares each and every night. We have lived in fear. We put cameras on our house because we thought Dolan would come to our home and kill all of us because he's a family of Pawtucket evil cops. Cameras that a neighbor put in for free because we have lived in fear. Now he's gotten what he wanted, so now the fear isn't so bad. He has PTSD, paranoia when driving, intense physical and emotional anxiety. Dominic had to cancel his first year in college. If you're a parent, you know what a big deal that is. No, he was home having nightmares, panic attacks. He couldn't even write. He's left-handed. Dolan aimed to kill him because he was enraged, as he always is. I have been told by police in high positions, officers are trained, shoot to kill, center mass. My son flinched when Dolan had the nerve to say, "You're going to be shot." And my son flinched, and that is how he got shot, in his humerus and shattered, and not in his chest, over rage. My son was only 18. Imagine your child, niece or nephew, your spouse, he's going after adults. How you would feel. They are protecting bad police officers. You've had 2 years. Tell my son he matters because the criminal justice system didn't. Tell my son his life matters. He's been suicidal. While Dolan is home collecting $123,000 in weekly pay, laughing all the way to the bank. His father swore at my son and me in the courthouse, a retired Pawtucket cop. A family of Pawtucket cops. I grew up in Pawtucket. I have to be careful when I'm there because I don't know who might go after me. I'm not going to remain silent for the next victim because there will be another victim. There will be. If he killed my son, I don't think he would have been put in jail because cops don't go to jail. Tell my son he matters, please. Tell my son his life matters because sometimes he doesn't think it does. And this evil man is the one who's sitting home. Domestic issues and a whole slew of others that you know of and maybe some you don't. Those are the ones he's only gotten caught doing. You have the power to act in the best interest of the citizens of Rhode Island, not just my family. I am not asking for my family. He has done so much damage, and there are other bad cops and good cops. The bad ones are the ones we're afraid of. I fear the police now. I'm not happy anymore. I can't even think straight. Daniel Dolan has proven with his actions he is a danger to society. Please vote to repeal Bill 5567. Thank you for listening and giving me the time. I truly appreciate it.
Thank you, and I just want to let you know, because I know you all feel like you've been shortchanged. Your civil lawyer that is handling the civil case, I've known him since I was 14. I've talked about it extensively with him. So I'm well aware of what happened and what to do about it, okay?
Thank you, because we feel like nobody cares.
I do.
I care.
Representative Batista. Wait a minute, somebody's got some questions.
Good evening, ma'am. I just wanted to say thank you. I understand that there's a lot of different things happening, that there's only so much time we have tonight. I just want to acknowledge publicly your strength, your courage. I know it may feel, I can imagine that it may feel in certain moments like you are alone, like your son is alone. I want you to know publicly you are not. There are hundreds of thousands of Rhode Islanders who agree that what happened was wrong, and we're committed to working to making sure this system does not permit something like that again. Thank you very much for your time.
Thank you very much. Yes, question? Representative Cruz.
As someone from Pawtucket, 3 generations, I know exactly what you're talking about. My father was shot in the back by police. My mother was beaten. So I want to thank you for your bravery, for coming forward. And I'm a mother of 4, so I can imagine the pain, but thank you for your bravery. I know how brave it is to come here and speak out against this egregious behavior, this corruption, this gang mentality.
My brain
so
doesn't
thank
think
you.
right anymore.
Thank you very
and my
much.
son's a good boy and a good student, and he is kind. He is kind. He didn't deserve this.
Thank you.
Okay.
Thank you very much.
Now, another bill I want to put into play. It's sponsored by myself. Get it in a minute. It's an act related to criminal procedure and arrest. It allows the change of the statute to allow college security to have the right to detain criminal offenders. Welcome.
Thank you, Mr. Chairman. Am I on?
Yeah,
Okay.
I think so. Is the little red light on?
Yes, it is. Thank you,
Okay.
and members of the committee.
Could you state your name for the record?
My name is Stephen Bannon, and I am the Executive Director of Public Safety at Bryant University, and I also serve as the President of the Rhode Island College and University Public Safety Administrators, or ICUPSA, which is essentially a group of 11 police chiefs and directors of college public safety, police and public safety departments. I'm here today to testify in support of House 5215, which would allow Rhode Island's private college security officers to temporarily detain individuals who are suspected of committing criminal offenses on their respective campuses. As you may imagine, college public safety officers regularly encounter disorderly persons, assault suspects, vandalism incidents, among other crimes on our campuses. Most often, these situations involve persons who are under the influence of both either alcohol or drugs or both. When these officers decide that the persons involved should be criminally charged and the police are contacted, they're in a position where they have to temporarily detain the individuals while waiting for the police to arrive. In some cases, the persons involved may become violent and physically resist being detained. In some cases, it may take the police 10 or 15 minutes to arrive. Although you may think that that's not a long time, when you're engaged with someone that's actively resisting, 1 minute can seem like 10. In order to protect officers, some colleges allow officers to carry and utilize handcuffs. However, some colleges don't, because as I speak, there's not a specific law in the state of Rhode Island that allows private college security officers to detain criminal offenders. At Bryant, I actually do equip my officers with handcuffs and provide regular training for them in defensive tactics and handcuffing. I believe it's in their best interest, in the best interest of safety on my campus, to allow for this detention and also for the officers to protect themselves and others who may be present. We also have a very detailed use of force policy that specifically spells out when and how force can be used. Currently, the only authority that I rely on, and the other privates that do provide handcuffs rely on, is Section 12.7.16 of the general laws, which I believe was developed under common law and allows any person to detain anyone who has committed an offense, basically a citizen's arrest. Admittedly, we may be walking, and I feel I'm walking on a thin line, relying on this very vague statute. Day in and day out, hundreds of public safety officers patrol the many college campuses on our state, and they protect thousands of students, staff, and faculty. These officers are sometimes thrust into situations where they have to intervene, stop criminal conduct from continuing, and protect themselves and others who may be present. And as I sat listening to the testimony of the prior bills, I just thought of really, honestly, the most egregious situation you can imagine, an active shooter situation. Imagine a person on a private college campus who confronts an active shooter who's doing serious damage, and that officer has the courage to overtake and detain that person. Currently, we don't have a law that specifically allows them to do that. So for these reasons, and Mr. Chair, I believe you also have a letter from Sid Wardell, the Police Chiefs Association, that supports this legislation. And for the reasons I've outlined, I ask for your support, and I'll entertain any questions if anyone should have them.
Any questions for the director? Thank you.
All right, thank you.
Okay, now we're going to start taking testimony on the 3 LEOBOR bills. So I'm going to take them in order on the 3 bills sign-up sheets. And when you come forward, there's many people who've signed up for all 3, 2 of the 3, only 1. When you come forward, please testify on all of the bills on this subject matter you wish to testify on.
Chairman, I think there's a 3rd LEOBOR bill that hasn't been put into play yet.
Yes. 6200.
All right, hang on a minute. I know whose bill that is. Thank you very much. Representative Batista, 6200.
So I know the 6200 is the LEOBOR bill. Should I just introduce that one or put them all in play at the same time?
Why don't you go ahead and put all your bills in play, because people may find that there's crossover there as well.
Thank
Okay?
you. In that case, I want to just address all of them and try to be as efficient as possible. There's a good
Sure.
6 or 7 bills.
Let's
Thank
start
you.
with 6200.
Thank you, Mr. Chairman, members of the committee, colleagues, friends, witnesses, and guests. To serve in this legislature is a privilege. To serve on this committee and have the opportunity to have this conversation we're having tonight is literally the reason why I ran for office. And it is without a question, the topic we're discussing tonight, the civil rights issue of our generation. I actually want to take a brief moment to recognize my predecessor, a former Representative Joe Almeida, who's here tonight. It makes me very happy to see you, Joe. Thank you for being here tonight. While there are many bills on the calendar tonight, including 6 of my own, I think the most efficient way to address tonight's overwhelming calendar is to take a step back and to try to find what is a common thread within all the bills, an overall goal for the bills proposed, and the reason why there are countless people here to support the changes and to tell their stories. Mr. Chairman, if there's one thing that we want to talk about tonight, is the fact that some of the most important systems in our state, as far as the criminal justice system, judiciary, and prisons, are broken. Let me be clear. When I say that they're broken, I am not talking about the human beings that make up the system and go to work every day trying to do their best. I'm not talking about the mothers and fathers and friends and neighbors who serve as police officers, court clerks, correctional officers, and judges. The devastating genius of injustice in 2023 is that it is not perpetrated necessarily by individuals or by malice, but rather, fittingly, today, on the anniversary of the murder of Martin Luther King, as he used to say, injustice today is the product of the inaction of good people, as opposed to the action of malicious people. Mr. Chairman, there is a clear thread in the history of this country that begins with slavery, evolves into Jim Crow, and graduates into what we have today, which is mass incarceration. We thought we got rid of Jim Crow. Instead, what we got was Jim Crow Esquire. And I look across the table here and I see my colleague Leonella Felix, and I think about all the young people in our generation who had the privilege to go to law school, not necessarily because they wanted to be attorneys, but as a strict matter of self-defense. For example, Some of the injustice created today is the result of laws. There are such things as, in the federal system, prosecutorial, or the lack of prosecutorial discretion, that says that a tiny amount of crack cocaine associated with the poor is the same to trigger the same mandatory minimums as an amount 100 times greater of cocaine. The problems that we have are systemic and institutionalized, and it is those systems that we're trying to fix, not necessarily the people that fill the roles. And so with that being said and that foundation laid, I would like to say a little bit about each of the bills that I've introduced today and conclude with talking about LEOBOR. Bill number 5569 discussed jury selection. A few years ago, this legislature made it so that people who are convicted of felonies but completed serving their time in prison can vote. It restored the right of convicted felons to vote. We never completed that cycle and have not restored the right of convicted felons to serve on a jury. Constitution says that we're supposed to have a jury of our peers. Taking the increasing amount of African American and people of color who are served on probation to take them off of the jury rolls means inherently that we are not being judged by a jury of our peers. This bill would fix that. Bill number 5583 would clarify the way in which we define conviction. Right now, not every sentence that are issued by our courts is a conviction, but conviction is a term of art that has massive consequences for someone being able to qualify for public housing, food stamps, or college aid to go to university. Bill 5583 would clarify that if you are sentenced to a fine, that alone does not equal a conviction as it does today. Bill number 5582 is significant. It would bring an end to what we call the war on drugs. It would decriminalize the possession of any and all drugs and would, instead of giving criminal sanctions, give a $100 fine for a first-time offender, $300 fines every time thereafter, and drug treatment if there are sufficient offenses created in a row. It is important to note that more than 50% of all revenues collected under this bill would go to drug treatment programs to prevent other people from falling into the same vice. Bill number 5568 is the Law Enforcement Integrity Act, which would limit the force of chemical agents against protesters. This was a bill that was introduced verbatim in the state of Colorado and passed in the immediate aftermath of the death of George Floyd. It also enforces a duty to intervene by one police officer who witnesses excessive force by another. It curtails qualified immunity at the state level, opening the door for civilians to file lawsuits for their constitutional rights. And Bill 6199, which I have the good fortune to work with Senator Coleman with, would ban the civil arrests by agencies like ICE in our courts. We have seen a disturbing trend with more and more people who may or may not be undocumented, some people who are documented and still have the fear of going to the courts, knowing that ICE might be there to execute an arrest. This makes us less safe. It makes people less likely to report crimes and participate in the criminal justice system. Last but not least, Mr. Chairman, finally, is Bill number 6200, a bill that would substantially reform the Law Enforcement Officers' Bill of Rights. Before I begin to discuss this issue, I want to give a public acknowledgement and thank you to the many people who have opened their doors to me and been willing to sit across the table from me and have a conversation about this bill, even though we have vastly different perspectives on what it does. John Rossi from the International Brotherhood of Police Officers, John Donnelly of the statewide FOP, Sid Wardell of the Rhode Island Police Chiefs Association, as well as the entire executive board of the Rhode Island Police Chiefs Association. I want to publicly acknowledge you, thank you for your hospitality, for the extraordinary conversations we've had. In submitting this legislation, we don't pretend to have all of the answers. I learned something from each and every one of these conversations that we take place. And indeed, I'm encouraged that through conversations with people we may not agree with people with different perspectives, is the only way to reach a solution for a bill as big as this one. Separate from that, I want to thank all of my colleagues, specifically Deputy Speaker Hull, who put in legislation today, and Representative Noré, who is not currently here, who have also shown me their hospitality and willingness to have difficult conversations on this issue. Last but not least, I'd like to thank the various community groups who have spent countless hours and resources fighting for legislation like this, not the least of which would be the Black Lives Matter PAC. Bill 6200, how would this change LEOBOR? There's a lot of areas in which I agree with some of the other reforms that have been talked about today, including Deputy Speaker Hall. I think we should expand the panel from 3 people to 5 people with 3 civilians. I think that we should make it more, make it simpler, make it more flexible for police chiefs to make comment on ongoing issues. There is, however, one very important distinction with my legislation as opposed to the other bills. My legislation would empower police chiefs to implement discipline for police officers rather immediately. It would not wait for a LEOBOR panel to finish before a chief can implement discipline, but it would honor and acknowledge the labor laws and actual due process that is required to give to police officers, mainly being what we call in the legal world a Loudermill hearing. If you're accused of misconduct, I agree. The police chief should not be able to just snap a finger without doing any homework and issue discipline. But after doing an investigation, after presenting the police officer with the accusations made against them, after giving the police officer the right to retain an attorney and respond to the allegations made against them, once this conversation has been had, there is no reason in law or in policy why a police chief should not be able to implement punishment at that time. Indeed, many other states do it this way, and contrary to what has been stated in some contexts, this is not against due process. Due process is the process that I outlined. Somewhere along the way, the bill here in Rhode Island has become one of the most favorable bills for police in the state. In no other state can police officers, first of all, have a board made completely of police officers, select one of the police officers on that board, and also have a voice as to who is the second person on that board. What began as a very valid exercise in providing due process to police officers that we should acknowledge and is proper has been overblown and overgrown into something that experts have called supersized due process. I just want to state one last point quickly. Where does LEOBOR come from? The origin of LEOBOR actually comes from a case that came down from the United States Supreme Court in 1967, if I'm not mistaken, Garrity versus New Jersey. In this case, there was a police officer being investigated for a ticket-fixing scheme. And when he was questioned about his role in that scheme, he was told, you can observe your right to remain silent, as every citizen can. But if you reserve your right to remain silent, we will fire you. The police officer answered questions. That information was used to convict him, and he appealed. The Supreme Court agreed with him. Police officers should not be compelled to testify. They have the same constitutional rights just as every other citizen. That is okay. We don't disagree with that. What we do disagree with is where that due process has been overblown into what it is now, in such a way as to make it more difficult to process complaints and ultimately more difficult to acquire accountability. So I appreciate the opportunity to be heard. This is a gigantic calendar. It's a very important theme. Every single one of these bills, whether it's LEOBOR or not, deserves our full attention and consideration, and I, at that point, will yield the floor. Thank you very much.
Thank you very much, Jose. Yes, Doc?
May I?
Yes?
Representative Batista, on 5582, if I read this bill correctly, and correct me if I'm wrong, you are replacing criminal violations with civil violations. Am I correct?
That's correct. What I would outline is that I'm very clear about the possession of drugs, not about the selling, dealing, distributing of drugs, the possession of drugs. If you have an amount for quote-unquote personal use, that is what I'm saying should be completely decriminalized, replaced with a civil violation.
Again, maybe I'm not reading correctly, but the parts of the present law that is being deleted talks about manufacture, deliver, possess with intent to manufacture or deliver, and that's replaced by possession. But everything else has been eliminated, with the exception of a counterfeit substance. So again, I'm not the lawyer, but is that what you want to do?
Now, to the extent that the language doesn't reflect the intent, I'm happy to work with the attorneys to make sure that it does. I do not want to address the distribution of drugs.
Because the way I look at it, and the lawyers here can correct me, you struck out, whoever wrote the law struck out, manufacture, deliver, possess with intent to manufacture or deliver. And it looks like it's been replaced by possession and went from criminal to civil. And again, I'm not sure you want to do that, nor am I sure this House of Representatives would want to do that.
Yeah, I mean, to that extent, I'm happy to work with legal counsel to make sure the language does what it is we need it to do, but this is specifically about possession. That's the intent of it. And this is with precedent. There are other jurisdictions, other countries who've taken this approach towards drug use. In fact, we've heard bills here about, you remember some of the bills we've heard on the floor regarding this issue. And so that's just what I meant by it. Happy to work on it if there are parts where the language...
Representative Batista, through the chair, if we could direct our legal counsel to see if I'm wrong or right, not now, but at some point in the future as they review the bill.
Johnny, you get that? Thank you.
Thank you, Mr. Chairman.
Thank you. Okay, first witness on the LEOBOR bills, John Rossi. And Michael Iamundi from Providence. And Hannah Stern from the ACLU. Is Hannah Stern here? Oh, overflow room? Okay. All right, thanks. John, you can testify on all the bills.
Yes, sir. Can you hear me?
Is the red light on?
The red light is on.
Okay, there you go.
All right. I want to thank everyone for the committee to give me the opportunity to testify today. I am John Rossi. I am a national service rep for the International Brotherhood of Police Officers. I'm testifying tonight in opposition to all of the bills that have been presented about LEOBOR. There is one, however, that would be H5888 that I think that in its present form we can't support, but we believe that we're working to resolve that so that we can support that bill. LEOBOR is nothing more or less than due process that's afforded to public employees. And LEOBOR is the sole remedy for the due process for those police officers who are also public employees. I'm trying to be brief. I have testimony prepared for each and every bill, but to sum it up, we are definitely in the camp to reform the law, right? We realize that it hasn't been looked at in some 25 years, and that it needs to be looked at. Also, I think what needs to be taken into consideration, too, is that I believe law enforcement in this state has been at the forefront in not only accepting body cams statewide, that's being rolled out, but taking a position to advocate for those. Everyone in this room wants good policing. Representative Batista was kind enough to meet with me, and we do agree on many issues. There's some fundamental disagreements that we have. We actually have a lot in common. But I have to have a fundamental disagreement with him, but I don't have to be disagreeable with him or anyone on the panel who, on the committee who feels otherwise. We're committed to reforming this law without a major overhaul that would impede police officers' due process rights as public employees, rights that have been conferred to them by both the U.S. and the Rhode Island Supreme Court. And that'll conclude my testimony to be brief.
Thank you, John. Any questions for John? Mike?
Thank you. Thank you, esteemed panel.
It's not, there we go. Okay, so I'm Michael Iamundi. I'm the president of the Providence Fraternal Order of Police, representing the capital city of officers. So I just want to touch briefly on a few things that, John testified to just now. We all agree that changes are coming, okay, and changes need to be done to LEOBOR. It's to what degree is reasonable, okay? That's what we're looking at, something that's reasonable. Keep in mind that we're one of the only professions in law enforcement where most of our decisions are split-second decisions or decisions made on the fly, right? So you're prone to, you may make a wrong decision or you may have a wrong action, but was the intent of the action malicious in intent? Was it to be harmful, or was it done out of good faith thinking you were doing the right thing at the time? So, and that has to be taken into account. And, LEOBOR was put in place years ago because of the frivolous complaints that were placed against officers through the, who may have a friend that knows the mayor or the chief and, may not have liked the way a call was handled, even though if it was handled properly, and then that officer would be disciplined for that with no recourse. So that's some of the basis behind of LEOBOR and where it started. LEOBOR is not there to protect the officer who does something that's criminal. It's not there to protect him from being disciplined. It's just to give him the fair process of an appeal should he feel or her feel, he or she feel that the discipline is not warranted for their actions. And it gives them a platform to speak from in their defense. That's basically all LEOBOR does. It doesn't impede the ability of a chief of police to impose a sanction on an officer. Everybody's under the impression that he or she, as a chief of police, can only impose a 2-day sanction before LEOBOR is invoked by the officer. That's not true. That's a falsehood, okay? A chief of police can put upon any discipline he wants if the officer feels it's, highly, what's the word I'm looking for? It's more of a discipline that should have been imposed given past histories or disciplines that have been imposed in the past for the same infractions. He has the right to go to LEOBOR at that point. But on many occasions, officers will accept pretty much just about any discipline the chief gives them. And I'll give examples of, we've had an officer take a 10-day suspension just for saying, who wants more? Now, given the situation that taken place in, it made it look bad, right? It made it bad. But those words ended the situation. It stopped it from going any further. It stopped it from getting any worse. So it actually de-escalated the situation rather than escalated the situation. And he took a 10-day suspension for that, just for those words. We have another case where someone was standing on a body-worn camera, which is evidence of a crime, and they wouldn't move. And when the officer pushed the person off the camera to get his camera back, he took a 2-day suspension for that. Now, we all want the body-worn cameras to work. We all want them to work in our favor, right? So it shows everybody the transparency of what's going on, but yet you want to suspend an officer for trying to retrieve the evidence that's going to show that. And he did nothing wrong. He didn't hurt anybody. He just pushed someone away from it. So LEOBOR, they didn't invoke their rights to LEOBOR because they felt, I'm just going to take my suspension. I'll take my licks and I'll go away from there. We've had another officer who lost his job in LEOBOR over the last probably 15 years now, where he made an off-colored comment. He thought he was joking with people. People didn't take it as a joke. He rolled the dice. He could have taken a lengthy suspension. He rolled the dice. He got fired. He got fired for one incident in his 20-year career, a verbal incident, and he got fired. So LEOBOR works. Currently, as it's written, it works. And I understand that we need changes, and I understand that there's transparency that needs to be, that needs to be there for the chiefs of police. They need to be able to speak more openly about them and whatnot. And we're not in disagreement with changes that are coming, okay, or some of the changes that are coming, I should say. We are on board. We have been sitting down with the police chiefs associations. We've sat down with several representatives. We have tried to come to a reasonable agreement that could be pushed forward, that would be acceptable to all parties involved. And, we're here trying to come to that agreement that can be agreed upon by all of you. Okay, something that's not going to change the due process. Well, I shouldn't say not going to change. It's going to alter the due process for the officer because it's going to impose some different sanctions, but it still allows that officer to have his due process, just like anybody else would in the civilian side. If they were accused of something, they have a due process.
Thanks.
So,
Mike, you got to wrap it up.
Is that?
Mike, I'm over here. You got to wrap it up.
Oh, okay. All right, so I'll just leave it at that then.
Thanks. Hannah?
Thank you very much, Chairman and members of the committee, for your time this evening. Hannah Stern, testifying on behalf of the ACLU of Rhode Island. I'm addressing all three pieces of legislation, if that's okay. All right, great, thanks. The ACLU strongly believes that it's time for significant revisions to be made to LEOBOR or repeal to be considered. The scope of protection given to law enforcement through LEOBOR is just extraordinary, not just compared to other public service personnel, but even in comparison to the rights of criminal defendants. And as you heard earlier, especially considering that we're one of only 2 states in the entire country that doesn't actually have a decertification process for law enforcement officers, it's clear that major change really does have to occur. I'll be brief. We've submitted detailed written testimony. I do just want to touch on 3 specific points very quickly. First, that of the bills that only seek to amend LEOBOR, which are before this committee tonight, we do urge support for H 6200 over H 5888 because it does make much more substantive changes. However, there is a provision in H 5888, which we do support and urge be included in H 6200, which is the repeal of language that actually restricts the ability for a statement to be made prior to a decision from the LEOBOR hearing board. This repeal critically strengthens public transparency. We think it's an important provision that should be included in any amendments which are made to this law. Second, we support the change in H 6200, which changes the composition of the hearing committee such that a majority of the committee is actually composed of civilians or those who are not affiliated with law enforcement. And finally, third, we note that a recent Attorney General decision and a preliminary Superior Court ruling issued 2 years ago provide an interpretation of our State Access to Public Records Act, which actually makes it very difficult to even learn about incidents of police misconduct. Under these opinions, the public is not entitled to see the departmental final reports of investigations of police misconduct, even with personally identifiable information redacted. This is obviously a huge issue for transparency, and we're very concerned that while amending or repealing LEOBOR is a really good first step, unless APRA is also amended to ensure that the public can actually see the final investigations of misconduct, that it could be a hollow victory. With that being said, happy to answer any questions. Thank you for your time.
I think you have a question.
Actually, not for you, Hannah. Mr. Ayamondi? You indicated in your testimony that you're, I know you're the head of the Providence Police Union, yes, right? So I'm not asking you specifically that, but law enforcement in general, you're a voice that you would be willing to accept some changes in LEOBOR. Can you be more specific and tell us what you think needs to be changed, or you would be willing to accept?
So I understand that the police chiefs are looking for more ability to be able to make a statement. So I understand that they can, they should be able to make more of a statement than they are right now, than they're able to do right now under LEOBOR. So to expand that, but still keep intact the integrity of the case for the officer. So if it's an administrative charge, which is something usually that's of a minor nature, you don't have to reveal the officer's name in something like that. But if it's a criminal charge, obviously you're going to reveal the officer's name. So, but you can also be more open as to, okay, this is what we're investigating, this is what's going on, these are the steps we're taking, this is what we've put in place as far as the disciplinary action for this officer. You can do that immediately. You don't have to wait until LEOBOR is invoked or anything like that. So we're agreeable to having that, move forward at a faster rate to put the information out. We're also agreeable to raising the days of suspension from 2 to, I would rather see a tiered system rather than the 14 days that's specified in one of the bills. I would rather see a tiered system, say, up to 5 days for something that is an administrative infraction. Then bump it up to maybe 10 days for something that's a little more serious nature, and then obviously if it's a criminal act, they're getting suspended, and that's part of what I was looking at, so.
Do you guys have a position on changing the makeup of the board?
So I personally don't want to see a change in the makeup on the board myself. I know we've talked. There has been discussion about the panel going to 5 and what that makeup would be, whether it would be someone from everything from judges to attorneys to Human Rights Commission. I don't think as a whole, and I'll only speak for myself, but we haven't come to an agreement as to who those extra bodies should be or where they should come from. But we're not opposed to having, you know, a broader panel, depending on what the makeup of the panel is.
Okay, thank you.
Any other questions for Hannah? Oh, I'm sorry.
What are some of the examples of administrative grievances?
So under the LEOBOR right now is if someone didn't want to wear a hat and they were supposed to wear a hat, you could suspend them for 2 days right now. And if someone shows up late for work or something like that, that's administrative charges. So, what's that? A car accident, you know, right now, if someone gets into a car accident, they can get suspended, they can get grounded for months on a time. So, you know, minor infractions of the rules and regulations of the department, not so much the criminal law. That's what I mean by minor. So if it's, you know, you're wearing a long sleeve shirt that day when it calls for by our general orders to be a short sleeve shirt, you can get suspended under the Bill of Rights right now. So, under the way they want to have it written. So that's what I'm talking about by minor infractions. I'm not talking about things where, you know, use of force, that type of nature thing. I'm not talking about that. I'm not talking about, you know, abusive language, things like that. I'm talking about the minor offenses.
Any other questions? Jose?
Thank you, Mr. Chairman. I have a couple of questions for both of the gentlemen on the panel. I'm going to begin with my friend John Rossi here. I appreciate the time that we spent together, and I thank you for your willingness to have a conversation with me. There was something you said, I'm not picking at you, but it's important, and I want to be clear that either A, I understand you, or B, we're maybe disagree on the issue, but I want to be clear. You called LEOBOR, quote, basic due process, right?
It's the sole exclusive remedy in the state of Rhode Island right now.
But I think part of the words you used were, you called it basic due process.
It is due process, yeah, basic.
Now I would contend, and you tell me if I'm wrong,
Okay.
the LEOBOR that we have in Rhode Island does much more than give police officers the due process that they're owed under the law and the Constitution, doesn't it?
I don't believe so.
So police officers are public employees.
Correct.
And as public employees, they benefit from all the laws that protect public employees.
Correct.
In part to say that the government can't fire you without some sort of process.
Correct.
I would submit to you, and you know, we don't have to say right or wrong right now, I would submit to you that the only part of LEOBOR that is constitutionally required is that initial Loudermill hearing that we were discussing. You're accused of doing something wrong, whether it be criminal or not. You're presented with the facts. You have an opportunity to have an attorney respond to the facts, do an internal investigation. Once that preliminary part is done and you're confronted with those things, that's essentially the due process that due process, check the box. Everything beyond that is extra. That is what I contend. If I'm legally wrong about that, I'm happy to have a conversation. I don't have a problem admitting it. But part of the issue that I think, and this is not personal, you know that, within these conversations, we use buzzwords like due process, and that confuses people, even who are lawyers, because we have due process under the 4th, 5th, 6th Amendments, right? You can't just be arrested and thrown into a black van and nobody sees you ever again. And when we talk about due process, what that Garrity case says is that when you're a police officer, you don't sign those rights away. If you're accused of a crime, you don't have to speak. Period.
Correct.
Period.
And LEOBOR is not, you know, you're not interviewed for LEOBOR. If it, in fact, right in the law, if it's a criminal act, you're advised of your constitutional rights and afforded an attorney. I'm talking strictly from an employment point of view.
Right.
And the vested property rights that I believe all public employees have, and I'm certainly not a lawyer, and so I'm not even trying to get into a legal wrangle with you.
I read that, I've heard that phrase a few times. I read it in an article today
Yeah.
talking about basic due process. And what I would respectfully submit, and you know, I know we're going to have a lot more conversations about this, LEOBOR that we have in Rhode Island is not basic due process. It is a lot more than that. All right, and we'll continue that conversation.
Yeah, I've probably going to disagree with you on that, but okay. I can understand where you're coming from, right? I mean,
I appreciate that.
You know, I think the Senate Commission was about everybody who's, myself and my friend from Providence FOP, is I think the Senate Commission was about transparency, right? And that's about the statements that can be made, right? So I tend to agree that the limitations placed on the chief is not good for anyone involved, right? So transparency, and I think the other takeaway was expansion of the panel, right? And we had a conversation. I have sat on LEOBOR boards, hearing panels, and I can tell you right now, and I told you this, that I welcome a judge to be part of the panel and be the chairman of that panel, right? I welcome that, because the way the system's set up right now, the fact of the matter is sometimes it's baked into the pie depending on who the neutral is out of the three offices. So expansion of the panel, transparency, and lengthening of the days in terms of what you can get suspended for. Now, 14 days for not wearing your hat. There's been a recent LEOBOR case where someone got charged with not saluting the mayor, right? And looking at termination. So let's think about what that 14 days means. I did some quick calculations. Probably anywhere between $4,000 and $5,000 that you'd have to take a hit for minor infractions. You weren't wearing your tie. And with the implementation of body cams, there's going to be auditing done to those body cams. And randomly, they're going to pick people every month and just going to pull your tape. Don't have your hat on. And it says right in the policy that was developed that you're subject to discipline. So that's what we're talking about. Anything else besides employment, infractions of the rules and regulations, we're talking about something else. I think everybody in this room, everybody in Rhode Island wants good policing, right? We want good, clean policing. We don't want bad apples in our profession, not at all. And we're working towards trying to reform this law so that parties will be satisfied. I think there's some people who have a fundamental belief that police culture is one of cover-up, is one of sort of corruption in that regard. And I'm proud of my career. I never played that game. The chips fall where they may, right? So thank you. And I didn't mean to go off on a tangent. I apologize.
Thank you. Yes, go ahead.
I appreciate that. And listen, I say this, my father was a police officer for a long time. He got caught up in a lawsuit where a kid died in custody in a jail out where I grew up that he was on the clock for about this long, but he was wrapped in with the defendant. So I get that. I get not wanting to be nickel and dimed, particularly in a paramilitary organization where you really don't have a lot to say. I get that. What I'm trying to get to is the solution that prevents an Officer Dolan situation where he may have been not guilty in front of a jury, but everyone agrees that those were not the appropriate actions of a police officer who was off duty at the time. And, and now the city is saddled with a money debt to a guy that no questions asked shouldn't be on the job. And it's because of LEOBOR. So like the small stuff, I'm with you. I see where you're coming from, but we got to fix it so that the big things like that, don't happen. It's my 2 cents. It's not a question. It's just my 2 cents.
Okay. Thank you.
Thank you, Mr. Chairman. Thank you, everyone.
Next panel is Jonathan Tuttle, Jeremy Costa, and Jim Vincent. Oh, I'm sorry, Harrison Tuttle. Yeah, all three of you can go up. Yep. And so the next group will be individuals. No, I know. Will be individuals that are opposed to these bills, and they'll be Chief Matthew Moynihan, Chief Kevin Lynch, and Sid Wardell. You'll be the next three. Fellas, Jim, it's up to you. Harrison, he's the oldest guy. You got to give him.
You sure?
I do, yeah.
All right. My name is Jim Vincent. I am the immediate past president of the NAACP Providence branch. And I'm also a senior advisor to Black Lives Matter, Rhode Island PAC. And I'm also a former member with Representative Baptista with the Senate Commission that was alluded to earlier that President Ruggiero had put together with Senator Metz. And I'm here to say that I am even stronger in support of a certain position now after hearing all of this than ever before. I am strongly in favor of repealing LEOBOR altogether. I've heard enough. It's illogical, it's irrational. 36 or 37 states don't have something that Rhode Island says we need. How can you need something where the other 5 New England states don't have it? I'm not against law enforcement, I'm pro-accountability. And for me, I understand the difference between police officers, teachers, public works workers, and so I'm not trying to debate the difference between those workers. But I do understand that there are police officers in Massachusetts and Connecticut. So let's look at apples to apples. As Representative Baptiste said, they're not going to lose any due process. What we have here in Rhode Island is due process on top of due process, and maybe even on top of that, which is ridiculous. It's redundant. You know, we've had it for many, many years. In the beginning, we probably needed to have it because you had chiefs that were acting in a rogue fashion, probably over-disciplining people for the frivolous things. But that was 60 years ago. 60 years ago, life has changed. This world has changed, all right? So I have never heard one credible or rational response to why we should keep LEOBOR in the last 5 years that I've served as the president of the NAACP and as far as being a member of that commission. Not once have I heard something that made sense to me. I'm not the smartest guy in the world, but it just makes no sense other than the fact they said we've always had it. I said, well, we've had Ann and Hope, we've had Benny's, and we don't have that anymore. We learned to live without them. Why can't we learn to live without LEOBOR? It's simple. You don't want to have something that's unnecessary. Arguably, the hardest state in the country to discipline an officer in the country is Rhode Island. Why are we so unique that we're the toughest state in the country to discipline an officer? I testified when that officer made that racial slur and was fired in LEOBOR. It took over a year to fire a person that in most states, maybe 75% of the states, would have been fired in a fraction of that time. Police officers say that the most important part of their job is police-community relations, and that the stronger the police-community relations is, the better it is for them and for the citizens. They say that, and I agree with that. Police-community relations has to be strong for good policing, for good accountability. Well, I can think of nothing more injurious or harmful to police community relations than LEOBOR, this structured LEOBOR, the due process on top of the due process on top of the due process. You heard what happened in Pawtucket. Okay, that officer hasn't even been before the LEOBOR Commission because you cannot go before LEOBOR until the criminal case is adjudicated. And mind you, if it's a guilty, they can appeal to the Superior Court, and you have to wait till that is adjudicated. So it could take a year, 2 years, 3 years to fire somebody that in most states would have been fired in 2 months. So I, for the life of me, can't understand the logic of having due process on top of due process just because we've always had it. Like I said, we had Benny's, we had Ann and Hope, and they're great stores. I love those stores. And they're gone, and I'm sorry they're gone. And I miss them, but I'm not going to miss LEOBOR. I'm not going to miss LEOBOR because it does more harm than good, and we just need to get rid of it, and let's get rid of it now, once and for all. Repeal the whole thing. Thank you.
Any questions for Jim?
Thank you, committee. That's why Jim Vincent goes first, right there.
That's, well,
It's, you know,
Get 'em older.
he knows where Ann and Hope is, or used to be.
Quick question for the chair. Do you want me to testify for all of the bills?
Yes.
Okay, great. Thank you, members of the committee. I'm going to testify first for the repeal of LEOBOR. Black Lives Matter, Rhode Island Political Action Committee strongly supports the repeal of LEOBOR. And, you know, a lot has been said. I want to first off commend the Vincent family for coming out here today. And, you know, it's reliving the worst day of their life. And for them to come out here to tell their story is incredibly important. There are a couple of things that I want to get into and break it off into segments. The first element is transparency. When an officer does something wrong, the public deserves to know everything about what that officer's future is going to look like. Unfortunately, right now, we have a gag rule where the public safety commissioner at the time, and now Mayor Brett Smiley, as well as the police chief, cannot say anything about the situation. What that does is it creates a sense of distrust. What that does is it creates a situation in which it further perpetuates the fact that police are looking to cover things up when they do something wrong. And so aside from that, If we choose to continue to keep the LEOBOR process, which I disagree with, I would make a recommendation that we keep the committee hearings open to the public or the media so people can come and see the process as it works. As of right now, it's very hard to know, if at all, when those LEOBOR hearings are happening. And those LEOBOR hearings cost $30,000 per hearing, and they happen 1 week. And so it's costing the taxpayers money to have a process in which the rest of the country does not have. I got to speed it up. The second thing is accountability. I don't know when Officer John Lugo is going to be working at all. I don't know if he's going to be working in Warwick. I don't know if he's going to be working in Providence. I don't know when Sergeant Hanley, who has been off the police force as an active member, is going to finally have his LEOBOR trial, which is going on 2 years because he was found guilty of a criminal charge for assaulting Rashad Gore. But he's still getting benefits. And most likely, if this bill does not include making sure that there are significant changes, he is going to get his benefits and is going to get his retirement plan because he exceeds 20 years. So there's a real urgency, not only from the victims, but also from a legal perspective and a financial perspective. The last thing that I will say is, I don't want to be here next year. I don't want to be on the news this summer or whenever the next incident unfortunately happens and says that the reform version did not do enough. I don't want to do that. I don't want to come back here, and unfortunately my fear, not to bash Deputy Speaker's bill because I want to work with him, I don't want to be back here and say, well, the same thing that happened with the reform, Sergeant Hanley would still be able to have that process. The criminal process would have to take place and would have to happen over the course of multiple months, sometimes years. And I don't want to do that. I don't want to come back and bash somebody's bill when we can have the opportunity to get something right here. Should I go on to the next question?
Are you done?
Yeah, I'm done with my LEOBOR testimony.
Oh, okay. So we're just sticking on LEOBOR right now, I think.
Okay,
right?
so I'll just go back to the, because I have other bills, I'll just go back to finish them all, or?
How many do you have?
It's like 3, I'll be quick.
All
like
right.
a minute.
Go ahead.
All right. So the next one is Representative David Morales' bill that would prohibit the use of armed police drones. Dave Morales brought up a lot of great points. I just want to say and reiterate the fact that we have a situation in which the places that it has been implemented in New York and San Francisco, immediately the public has said, no go, it's not something that's good for our community, and it's predominantly in black and brown areas. And so BMRI PAC supports a piece of legislation that would ban the use of police robot dogs. The third piece of legislation is a piece of legislation that would reform solitary confinement. Solitary confinement is incredibly inhumane. It causes significant mental and physical distress to the people that are involved in that situation. And I believe that throwing someone away in the darkness with no human contact is not the best way to be able to discipline people and create them on a pathway to get out of prison and be successful members of society. Lastly, the fourth bill.
Oh, you're on a roll.
Told you I'd be quick. Fourth bill would be to be able to have life with, make changes to the life with parole. And so BLMRI PAC supports that piece of legislation, as well as the amendments that were made by Representative Edwards. This is an opportunity for us to be able not only to save taxpayer monies by getting folks who are specifically going to pass away out of the judicial system and open up money for more important things like being able to have quality social services and make sure that people don't end up in prison, as well as programs in the prison itself.
Thank you.
Happy to take any questions.
Just respectfully,
Sure.
I also signed up and I support both of Representative John Lombardi's bills.
Okay.
I want to be on the record for that because I didn't know we were going to do all of them.
Very good. Thank you, Mr. Vincent.
Thank you.
And Jeremy?
Yeah. Let me turn this on. All right. Well, good afternoon, good evening. First, I want to recognize some unbelievable testimonies from the parents of Mr. Vincent. I think that that was very heartfelt and warm, and I hope you guys digested that. I hope you guys listened. Many of you guys were walking around. Now, I'm going to talk about Mr. Hull's bill real quick, because it's just a lot easier just to break them down. Mr. Hull's bill doesn't go deep enough. It doesn't do enough, because the people that need to be investigating are still doing the investigation. So how can you pass a due process law when the folks that need to be investigated are actually doing the investigation? So that is a no. That is just, you know, I wish I could have the piece of paper, because I would tear it up right now. Mr. Hull has also said he's a representative of the law enforcement. We no longer, the community as I represent, no longer want law enforcement having the ability, because in any other business, it would be a conflict of interest, to be making laws that are going to be protecting, supposedly, our community. It's a conflict of interest. His testimony is null and void. His bills should be null and void. He shouldn't be on the committee to be submitting bills that have to do with law enforcement or judiciary. If you want to do health and human services, go ahead. But we need to understand, we need to stop these institutional restraints and continuing to put more institutional restraints on the body that you guys are supposed to be, which is progressive. We have come way too far in the past 2 years. I've seen the growth. And we cannot allow people that have infiltrated this body of work to be able to make the laws and to manipulate you guys to be able to do such.
Well, Mr. Costa,
I'm just saying.
We are duly elected.
Wonderful.
Every person you're talking about is duly
Wonderful.
elected.
And I appreciate that. 70,000 people have got an opportunity to weigh in to select you. You have a moral obligation to listen to the testimonies of the people in regards to these bills.
Okay.
So, the next one.
Move on to the next one.
Yes.
Thank you.
618, 6181. Is that correct? Mr. Baptiste, it's actually kind of like a, it kind of gets into it, but it doesn't get into it enough again. What it does is it actually allows us to be able to filter the process of the people coming into the business before they actually get the job, which those other ones don't do. It allows us to decide who and will be our guardians in the community. We have to maybe start rewording. What I liked about that bill, because he actually framed it. He actually gave it an act. He actually gave it some substance before he got into explaining it. But again, it doesn't do enough. It doesn't heal the pain that Mr. Vincent is feeling right now. It doesn't do anything for his PTSD, and it doesn't do anything for those that have been afflicted while these cops today, you know, walk freely, get paid on taxpayers' money that are paying you to do your job. So, again, I appreciate the work, the thoughts. And so now we'll go to 620, which is a combination of the 6181 and
That's
this one.
6200 by Representative Baptista.
Yes, Representative Baptista. Also a very good addition, which would be the 5 bodies of the 5 panelists, which would be 3 from the community, which if anything is going to happen, that needs to happen. Community needs to be involved. People that have been afflicted, people that have actually been a victim need to be on that panel. I seen 2 great representatives today that could actually body that. We don't need a judge that is going to be protected by law enforcement or mayors that have been protected. That is part of their syllabus to protect the judges and the mayors. We don't need them because we don't want any corruption involved. So no judges, no Department of Human Services, no DYCF, whatever you want to call it, any alphabet name you want to give it, we don't want it. We want community activists, community leaders, community representatives, people that have been afflicted by these police officers. And we'll go to Mrs. Stewart's bill right now, which is 5586, something like that. I don't know.
5567.
5567, yes. Wonderful bill.
Okay.
It is an amazing bill. You heard the testimony.
Mhm.
Her father was an officer. Here you have somebody that grew up in that type of environment, but still feels that there's too much due process. Again, and I don't want to reiterate all the things that were said that were very important. I just wanted to touch on a few issues. The man said that this, and Mr. Baptista touched on it, I'm just going to reiterate because I thought that it was just rhetoric. Due process afforded to public employees. I'm going to read to you the Constitution real quick, and I'm going to end it. No, I'm not going to read the full Constitution. I'm just going to read Section 4. So the Section 4 states in this, I'm going to tell you what due process is because you guys all need to hear it again. Every person within the state ought to find a certain remedy by having recourse to the laws. Every person. Every person.
We understand that. We do understand that.
Yes, okay, so you guys do read your Constitution. I'm just going to read it again for the people that might not be in front of us or at home.
You got to watch your time, though. You're taking.
But I had 3 different bills, so that would be a total of 6 minutes.
No, I don't think that's the way it's working. But you've gotten your point.
All right, well, let me just get because I want to make sure that you get to this last sentence.
Okay, go ahead.
Okay, so again, by having recourse to the laws for all injuries. Now we have a hand that was shot at. Or wrongs, which may be received in one person. Now, it says properly or character. Oh, let me just skip that one because this is most important. Every person ought to obtain right and justice freely and without purchase, completely and without denial. Now,
okay.
So
you've used up your time, Mr. Costa.
Oh, I did?
Yeah.
Well, I got plenty of other bills to talk about, so
All
I'll
right,
come
but we're
back
not
and
gonna-
revisit those
yeah, you
bills
can
later.
come back
All right,
again, because
all right.
we'll
But I
get
want
the-
to make sure that
Yes.
you guys address this bill in this session.
Yep.
This is the time to make the decisions that are going to affect many years. You guys have the opportunity to light the candle to many fires
Well, thank you.
and maybe blow out a few. Thank you.
Thank you very much. Next is Chief Kevin Lynch, Chief Matthew Moynihan, and Chief Sid Wardell. Huh? He's coming next. They want to stop, so they want to go. Only Kevin's supposed to be, so.
That won't happen again. So don't read my notes.
So I believe, Chief Lynch, you're the one who's going to do the speaking?
Yes, I will. To my right, your left, is Chief Sidney Wardell, our Executive Director of the Rhode Island Police Chiefs Association.
I don't think your mic is.
I guess I got to go a little bit closer. To my left, your right, is Chief Matthew Moynihan of the South Kingston Police Department, who serves
Well
as the
aware of
treasurer
him.
of the Rhode Island Police Chiefs Association and former captain of the Rhode Island State Police. I'm Chief Kevin Lynch of the Bristol Police Department, and I currently serve as the president of the Rhode Island Police Chiefs Association. And for the record, we heard a lot about discipline. I do have my hat on tonight, so I am not going to get in trouble for not having a hat on. This evening, we heard, and everybody heard in the chamber, a lot about, and just for the record, we do oppose repealing LEOBOR, and that'll be the first issue I'll address, but we do support Speaker Hull's bill, but we would ask for some modifications because I think people in the gallery are going to be pleased with the recommendations that the police chiefs in the union worked on to create deeper reforms even than Speaker Hull's bill. So we're I think we're in a good place, and I think a lot of people in the room are going to be happy about some of the things that they're going to hear. And I do want to credit my brothers and sisters in the FOP and the IBPO for working with us and for accepting the vast majority of these changes. So I think that's a good thing when the police chiefs and the unions can work together in harmony and draft something, because years ago, that would not be the case. But to address some of the things that we heard about, and certainly the grave incident that happened involving a Pawtucket police officer, you repeal LEOBOR, there's a lot of attorneys in the room. I would assume, and I can only assume, that if that officer was to be immediately terminated, he would seek some type of relief through a restraining order. He would probably appeal that for a wrongful termination suit, and he would end up in the Superior Court litigating that very same matter. can only assume that that would happen, but that's what happens in the other states that don't have LEOBOR. There are judgments against the municipalities for wrongful termination. In many of these matters, just because there's not a LEOBOR process, get vetted out in the court system. So the officers just don't walk away because there's no LEOBOR process. They exercise their due process rights and go to the court. So that's an important factor to understand. And the reason why, as chiefs, we support, we're the ones issuing the discipline. We're the ones that are charged with weeding out the bad apples. We want a process that is fixed. The Bill of Rights, if you go through the legislation, it's all about timelines. The chief has a certain amount of time to complete his investigation. The hearing panel convenes. They have to pick the panel amongst themselves. They have to convene and finish the hearing within 30. They can extend it to 60 and then write a decision. Every step along the way has a 30, 60, or a 10-day timeline for all of these procedural steps to make certain that the process does not linger on. And I can tell you, yes, the decisions can be appealed in the Superior Court, but they're a quasi-judicial panel. Right? It's an administrative hearing. And upon appeal of the Superior Court, I challenge anybody to find a case where there was an egregious finding of fact or a lack of a finding of fact by a hearing panel where the Superior Court has intervened. They trust the decision out of LEOBOR since inception. The Superior Court has truly honored LEOBOR decisions. So I want to talk about how and why we support what Speaker Hull is doing, but we think we have deeper reforms that are going to satisfy a lot of people in the room and some of the people that spoke in opposition of the bill. So we could talk about the discipline. You know, the unions and the chiefs got together. We know the Senate Commission agreed on 14 days. It was kind of a split vote, started at 30, ended up at 14. But we agree with our union partners that a 10-day suspension for an administrative matter is fair. Now, don't get hung up on the 10 days, because if an officer commits the infraction on Monday, Tuesday, Wednesday, Thursday, Friday, that's 5 times 10. That's 50 days. So it just doesn't mean because you can commit an infraction for multiple days, which would initiate multiple charges against an officer. So the 10 days is truly not the cap. It can be more days based on the number of days that there's an infraction and how the hearing and the charges are written. So the big issue is that the hearing panel. I'm going to tell you what I think is wrong with the current design of the Bill of Rights and the current design of Speaker Hull's bill. It currently stands that the chief of police gets a pick. The accused officer gets a pick. Both of those neutral arbitrators, quasi-judges, walk into the room with a position that may be in the chief's favor and that may be in the accused officer's favor. So now you've got 2 judges that are already been sent there and have a mission before they even listen to an ounce of testimony. What the Police Chiefs Association is saying that we pick 3 police officers that have no association with the accused officer, know nothing of the investigation. I've been selected by their police chief to serve on this particular panel. They go to a certified program. They get a shingle to learn. What does the statute tell me I can do? What evidence can be accepted at the hearing? What is my responsibility? They walk out of it. Roger Williams University puts on an excellent class. They walk out of that with official training. None of the current legislation and nothing in any bill that's been introduced has a certified hearing officer. Our thing is you have 3 neutral judges that are wearing a police uniform, have no affiliation. Their chiefs who are administering the discipline are sending in 3 people that are going to uphold the profession, and that we believe, over the test of time, has been very successful. The other 2 panel members, we agree. It could be an administrative hearing officer from the Department of Administration. Some states call him an ALJ, administrative law judge. We would also agree to a member of the Public Defender's Office. The only reason why we oppose someone from Human Rights Commission, as a former internal affairs investigator, there were many times when we were dealing with workplace harassment issues where the officers involved, or some of the officers, had filed a complaint with the Human Rights Commission. They're going to run afoul of their investigative body working on police disciplinary matters. So we feel as though that a member of the Public Defender's Office is going to be a better neutral arbitrator in making up that particular panel. We agree with Speaker Hull that a police chief should be able to make an initial statement. They should be able to inform the general public. The police administration is aware of the behavior which has been reported. We've ordered a full investigation. We could be working with the state police, the Attorney General's office, and we can inform them that the officer has been placed on administrative leave. We currently cannot do that. So we support Speaker Hall's bill, and we think that that's a step in the right direction for transparency. Conduct of the hearing. If you, many Bill of Rights decisions have been challenged, hearings have been halted midstream, there's a procedural violation. If a chief doesn't get out the list of witnesses, or he doesn't supply all of the evidence in a timely manner, if a hearing exceeds the 30 days, the 60 days, the accused officers have gone to the presiding justice or the Superior Court and cried foul. There's been a procedural violation. I want the hearing thrown out, and I want to be reinstated. The unions agreed. That's not in Speaker Hall's bill. We need to make sure that a procedural violation does not let an accused officer get a free pass. I covered the issues with the days of suspension. Whether it's 2, whether it's 10, whether it's 14, you're really just looking at a number. Because if the violation occurs over multiple days, the number can be times 5, times 10, however long that this person has committed this particular infraction. I think Representative Batista is going to like some of the things that we want to do. Now, I'm aware of a case where an officer was arrested in Massachusetts. The officer accepted an Alfred plea. For you lawyers in the room, you'll have to educate me on that, but I have a small understanding of an Alfred plea. Now, a conviction on a felony does not afford an officer a Bill of Rights hearing. He's off the job. He's not even entitled. Once he's convicted in the criminal court of a felony, he's off the job. However, if an officer takes a plea deal, that's subject to interpretation right now by the court system. Our recommendation would say any type of felony plea, Alfred plea, that officer is off the books. So we know of a situation, and we're trying to fix that in the current legislation. And I think there's legislation by Representative Batista. I heard testimony tonight that we don't have a decertification process. Yes, we do. And the post is a statutory assignment under Rhode Island general law. They're appointed by the governor. And those organizations, as anybody knows, have rules of procedure. And rules in the state of Rhode Island are law. So I can tell you that the Rhode Island Post has a process. You retire from the Bristol Police Department, you want to go join the South Kingston Police Department. Years ago, under the rules of the Post, you were certified for 3 years. If you left the policing for more than 3 years, you had to get a special waiver. But for that 3-year window, you were still certified. You could be sitting on the beach for 3 years, decide to join another police force, you were good to go. Your certification was clean. The day you walk off of a police department in Rhode Island, you are automatically decertified. If you want to join another police department, you have to get a letter of good standing from your chief, and you have to go in front of an administrative decision, which is noticed by the Secretary of State, and that hearing, that 8-member panel decides whether or not that officer is going to be certified to continue in law enforcement. So I have to call that, it's a fresh process. I want to say it's about 18 to 24 months old. And so we do have a de facto decertification process. The Rhode Island Police Chief's recommendation to sub-A Speaker Hull's bill will require any decision of the hearing panel to be mailed to the Post. So they will know if an officer has been disciplined in Bristol and South Kingston, in Little Compton or Cranston and Providence. Also, if that officer is terminated, we want to put that officer on a national registry. We don't want him going out to South Carolina, Florida, and picking up a shield in another state. So I want to thank the unions for working on us. This type of harmony in relationship with the unions, we always had great relations, but when it came to LEOBOR, they came a long way, and they deserve a lot of credit. They want professional policing just like the chiefs do. And we ask you, as an association, we are charged with running our police departments efficiently and effectively, and that includes discipline. We are the people that are invoking the discipline. I can tell you that LEOBOR works. In states that don't have LEOBOR, they're entangled with appeals. You know, as the lawyers in this room know, if somebody appeals a wrongful termination, that could linger in the courts for years. We'll never get the officer off of the force. If they commit an egregious offense and they're arrested for a felony, they're automatically off. For a misdemeanor or an administrative hearing, we have a process to do our due diligence. And really, to repeal LEOBOR would be doing us a discredit. And I speak for all of the municipal police chiefs. We believe that the process works. Have there been minor changes? I met with Rep. Batista in changing this bill. I said, Rep, let's go over LEOBOR decisions for the past 2 decades. Let's try to find where someone feels as though LEOBOR failed. Let's look at that individual case and make sure when we draft this legislation that we pick up any of those nuances to make sure that it doesn't happen again. I stand here ready to listen to those things and to recommend those changes because the Police Chiefs Association has a lot of respect for the work that our officers are doing in the field. We value what they do each and every day. And we know, just so everybody knows, we are down to 1 to maybe 3 hearings. 4 or 5 years ago, we were up to about 5 of these administrative hearings a year. Let's not forget that just 2 months ago, we put a body-worn camera on every police officer in the state of Rhode Island. That is going to change the climate for transparency. On top of that, this General Assembly in the bill said that an officer, each and every officer, has to be audited. A supervisor has to go in, and they have to go and check Chairwoman McEntee once a month and bring up a random call and view that video footage just to make sure he or she is doing the job correctly out in the field. We have the audit systems now in place. With these changes that the union agrees, we know, we respect that people want changes and reform the LEOBOR. It's here, and we feel as though that with the product that we've presented, we can fix all of the concerns that people have. Thank you.
Thank you, Chief. Any questions? Representative Knight.
Thank you, and thank you, Chief, for your testimony. I appreciate it. I want to go back, just because I maybe lost the thread there for a bit, to your ideas about the panel, because I think the panel is the key thing. If I heard you correctly, you were looking for 3 truly independent active duty officers who have nothing to do with the case and maybe even nothing to do with the department. Is that fair enough?
Correct.
Okay. And then you talked about maybe a 4th, which would be maybe a judge or perhaps a PD lawyer.
No, sir.
But can you go back and tell me exactly where your position is on the panel then?
So you're correct on the 3 police officers. In essence, I call it clean hands. They're all
Right.
walking in with clean hands. Nobody has been charged to carry out the chief's mission or the accused officer. Okay, the current way it's written and in Speaker Hull's bill still allow the chief to have a pick and still allow the accused officer. So you've got 2 judges walking in that may, I'm not accusing them, but I'm saying may have a disposition to represent their chief or the other one to represent their accused officer. Our modification calls for 3 police officers to have nothing to do with the case, to know we don't even want you to have an affiliation, if best possible, in Rhode Island with the officer. So we're really counting on sending in 3 police officers, and we're requiring for the first time ever in legislation that that person get a certificate, that they understand what the law is, what they're supposed to be doing in that particular hearing. Right now, it is a quasi-judicial panel with police officers with absolutely no training other than reviewing the law. And I'm not aware of any quasi-judicial panel that assembles and doesn't have formal training.
Would you be willing to consider the addition of perhaps 2 more members of the community who are not law enforcement? Because I think, I grew up around cops, and cops have a certain way of looking at things. And I can see 3 straight-up honorable police officers coming in and evaluating the thing and whatever happened. And I'm particularly concerned, obviously, about use of force and abuse and that sort of thing. I care less about the hats. And having a blind spot around some community expectations of what police should be doing in that particular community's neighborhoods, And I'm wondering how you would feel about having perhaps 2 additional people. I don't know who they would be. Obviously, they would also have to be trained. They would also have to be neutral, but could come and evaluate whatever happened from the perspective of the civilian.
I understand.
And to help inform the other 3 as they make their judgments about what happened. It says, you may think it's okay, and maybe by the book it's okay, but here, right there on the video at 45 seconds, there was an opportunity to perhaps back off. That wasn't taken. The officer got aggressive and tried to control the situation when maybe that wasn't called for. You know how it is.
I understand. I understand your point of view, and we count on civilians every day in our juries, to call the balls and strikes fairly, as you call it. But we feel as though that, police officers are put in very difficult positions, effectuating arrest. We're dealing with people under substance abuse, mental illness, violent people. And, it's a very difficult thing to say. You send a police officer to the academy, you get your police department state and nationally accredited, you issue a policy and a procedure, and you tell an officer you're to follow all of your training and all of the policies and procedures. And when an officer follows all of those, and let me tell you, every use of force situation looks ugly when you see it, right? You never walk away from a use of force situation and go, oh, that was done correctly. Thank God, the police officers were there. We just don't know where the arrows are going to come from these particular things. So it's very difficult when you don't know what the community or the people from the community that you're asking to do that. That's why juries are somewhat, they walk into it, as I call it, clean hands. They're selected because they're not a part of a group or an affiliation.
Right.
So that's why even representatives, we support a retired judge, an attorney, a hearing officer who understands an administrative matter, and we also support a public defender. From doing that. And we feel as though
sorry to cut you off, but as being additions to the panel?
As being additions to the panel,
That's what I was asking.
Oh, okay.
Because I was hearing 3 police officers, and that's it.
Oh,
you would consider a judge or perhaps a PD?
Absolutely.
Okay. Well, thank you for that. And one last thing, real quick. On the public disclosure front, do you have feelings about any sort of body cam video or any other surveillance video being released quicker as part of the chief's statement? And I say that with the caveat that I know there are videos and there are videos, and there are safety concerns and there are investigative concerns, and that depending on what's going on. But in general, I know that the public wants to see the video quickly.
Correct. We met with the Rhode Island Attorney General, Peter Nerona, and the Rhode Island Police Chiefs Association met several times on that particular issue. Subject to correction by my fellow chiefs, we agreed. So before the grant money was released, the Attorney General had to sign off, and a member of the state police, I think it was Major Lori Ludovici, and we had a working group, and we came to an agreement that when a criminal investigation was substantially complete, no more than 20 days, chiefs, that we would release that body-worn camera. So that, the Attorney General was very concerned about that, so that has been codified on when that body-worn camera footage is going to get released.
And those conversations contemplated the LEOBOR implications as well. Fair enough?
They contradict?
Contemplated. You guys were thinking about LEOBOR as well as all the other stuff when you were coming up with that policy. I know the policy's out there. I know, 20 days and the AG can okay it to be released. But that's through the, I guess if LEOBOR runs, if LEOBOR runs against the grain of that decision, it sounds like you guys are willing to make sure that
I guess
the way we set up body cams, if we were to change the LEOBOR law, we could incorporate that concept into the LEOBOR change so there's no questions asked.
Sure, I think both issues stand alone, but we have no problem with, being redundant and saying that the body-worn camera would be released.
Okay, thank you.
Okay.
Thank you, Chief.
Thank you. Can I just say one thing before? I just want to, I think what we're hearing today, and thank you for working on all of this, Chief, all of you chiefs, but it's the appearance that you're protecting your own is what I'm hearing from everyone, right?
Yes.
And that's, I think you're trying with the 3 officers that you talked about, but who would choose those 3 officers? Would we still be back to the accused and the chief, or who would make that determination?
we certainly have provided our recommendations in, to the committee for everyone to see them. But the chief of police would meet with the union president of the respective police department, and ultimately the chief will have to say. They would agree on submission. We looked at 2 names, so 39 cities and towns, the state police and Providence Police. They would submit 2 names to go to a list for the presiding justice of the Superior Court. If the chief does not agree with who the union would like to do, that police department does not have a submission. What they will do on an annual basis every January could be a new chief, could be a new union president, could be a new recommendation.
I see.
So every year they will try just so that they just don't go away. So the goal is to have some type of an agreement that the person that's being selected to represent your agency is a fair umpire. Nobody wants the Police Chiefs Association does not want the umpire riding the bus with any certain team. We want somebody that's going to drive themselves to the hearing and it's going to call the balls and strikes fairly.
All right, thank you, Chief. Representative Baptista, thank you for that. Let me.
If there's anybody letting anybody, it's you letting me. So thank you. Chief Lynch, thank you very much. I wanted to say thank you for being here and testifying. During my opening comments, I specifically thanked you and your organization for being so hospitable to me and for meeting with me and the various members of your executive board. And so I thank you for that. I just wanted to maybe ask a couple of questions to clarify a couple of things. I'll leave the post to the side. I learned through conversations with you and your team that of the post and the great work that it's doing, so I do recognize that there is a post, and I made that in my opening comments. One thing I wanted to talk about, I wanted to ask you one question, and I wanted to clarify something else. One question I would ask you, okay? One thing I learned in talking to different police chiefs is that every town, every municipality, and the needs thereof are different, right? So your needs in Bristol are different from ours in Providence and inner city suburbs, et cetera. And that point was a good one, especially when there's some municipalities that are more, have more appetite for reform than others, right? You need different tools. Speaking as the president of the entire organization, not just your municipality, are you not familiar with any examples in which any of your colleagues or chiefs have needed to implement some sort of discipline and have felt either delayed or hamstrung by this bill? Do you, in your entire career, and specifically in your tenure as president of this organization, are you not familiar with any example like that?
I've been in public service for coming up on almost 40 years. And certainly the sentiment, in the earlier versions was that, LEOBOR certainly worked in the favor of an accused officer. I have to give the profession credit. The officers, even the union officers in the officers' selection, have been calling the balls and strikes fairly. We look back, like I said to you, let's look back for a decade. Let's look into these decisions where you think an accused officer got off on a Bill of Rights hearing. We policed ourselves, when we looked at that, and it's a good question because I asked, speaking with Colonel Winquist, our secretary, and we think LEOBOR is working even in its current form. I know there are people that have trouble with it, and that's why we made all of these reforms. And the reform that we made on plea deals was something that just popped up recently. Officer was arrested en masse for a domestic felony issue, and there was a plea deal, an Alfred plea, and now there's a potential that officer may be afforded a LEOBOR hearing. Doesn't mean that the ultimate decision is going to be he's going to return to the force, but we feel as though that you're going to take a plea on a felony, you're off the job. We don't need those actors in the field. So yes, so when we saw that was something that a fellow chief brought up and raised an issue, and we think we closed that gap. Same thing for making an initial public statement. We know nothing gets the general public upset when we say, unfortunately, I can't make a comment as the chief of police because LEOBOR prohibits me from making a statement. We know folks want to know what's going on, what's the position of the officer, who's coming in to help with the investigation. The state police have been called if it's a municipality or the attorney general. We want to reassure the public that we're doing the right thing. So yes, those are the reforms that the chiefs have brought back and we have memorialized in our proposal.
That's a very good answer. It sounds almost like an answer that will come from somebody sitting on this side of the table as opposed to that side.
Not bad, we'll take it.
I wanted to, I made a point with John Rossi earlier about the words due process. And I would respectfully submit that even with good folks that I got to know with good intentions, the words, buzzwords like due process are being misused in this conversation. Not intentionally, not necessarily, but if we really dig down on what due process means, for example, I think we'd be a lot more inclined to pass a bill like mine as opposed to alternatives. Another example of buzzwords you brought up a couple of times, wrongful termination. I know there was a case in Massachusetts recently where a police officer was successful in bringing a wrongful termination case. I just want to clarify for the record, not that you misstated this, but I just want to be clear. If, for example, my bill were to pass, for example, and police chiefs were able to implement punishment after a Loudermill hearing, I say immediately, but it would be after due process. That alone would not give a police officer a wrongful termination claim. In order to bring a wrongful termination claim, there has to be some sort of allegation of that the police officer was fired, not just fired, fired because of a protected class, because of their gender, because of their age, because of a physical disability, because of something like that. And so even in that context where the chief would be able to implement punishment, it doesn't mean, if you fire somebody wrongful termination because they didn't like the process. It's because, you targeted them. And in that case in Massachusetts, the police officer had a very talented lawyer who was able to argue that the police officer was not drunk on the job, as he was fired for, but rather an alcoholic. And because that department was not willing to give that police officer the sort of need and resource that he needed to treat his alcoholism, that's why he was fired. That's why he actually won the case. And so I have a lot of trust in persons like you and chiefs, and I know Chief Clemens in Providence just retired, and I feel like we had a parade for him, and everybody loved him. And so part of our position is why not give the chiefs, talented, experienced, fair, the ability to make these decisions as opposed to prolonging that process unnecessarily.
I guess I would revert back to some of the original testimony on the origins, of LEOBOR when there was police chiefs that somewhat abused their power. And that was the genesis, behind the LEOBOR bill. And I'm certainly not here to accuse my fellow chiefs of abusing their authority, but that is the inception, of LEOBOR. And, to put an officer out and to say you're off the job, you have the right to go through a quasi-LEOBOR policy, but you're terminated until you come back. I just don't have the expertise, yourself, as an attorney. When you bring up the word due process, I'm sure you would agree that the word due process would apply if we did not have a LEOBOR process. That if an officer chose to go to the court and do a wrongful termination, that officer would be using some form of due process by going to the court. Whatever the definition or process, that's what we feel as though, that's what we know the other states are up against. And let's not forget it, Rhode Island's a labor state. These officers have arbitration. They can file a grievance and go to arbitration, if we don't have the LEOBOR process. And, arbitration on these particular matters, you're an attorney. Labor law has been around longer, and there's more case law for the employee over the employer, especially in the government realm. So that's why we think LEOBOR works. It gives us a level playing field rather than going through an arbitration and waiting for an arbitrator's decision. We know that there are pro-labor arbitrators. We know they're pro-administration, but the pro-labor arbitrators certainly outweigh the pro-administration. And I think we're going to get into a pool that is going to hurt us. And the reason why LEOBOR works, and there's a process, I'll avoid the word due process, for the conversation's sake, is because there's timelines. These folks can't stay on the books and linger in our ranks because LEOBOR is a tight timeline and it removes bad apples from our profession.
Thank you very much.
Any other questions by the committee? Okay, thanks, guys.
I want to thank you. I know my testimony is compassionate, but I appreciate everyone's time. It means a lot to us.
Appreciate it. Okay, John Donnelly, Jim Cinerini, and Steve Alquist. about Michael Tillinghast? Is Michael here? Is he? Okay. I'll wait for him. John, you're up.
Thank you, ladies and gentlemen. It's a tough act to follow, so I'll keep my comments brief. I am the state president of the Fraternal Order of Police. I've been a police officer for 18 years. I speak in opposition of these bills for many of the reasons that you've already heard. But I just want to say that the police union is not against reform, not against transparency. We're not against training. You see some of the steps like the body-worn cameras. These are things that even a year or two ago were not something we would consider. So we feel LEOBOR should change. We expect it to change. And for many of the same reasons that Chief Lynch and President Imundi and some of my, Mr. Rossi and some of my colleagues in police work, we feel that while it's effective and we think it's fair, it will change. We expect it to change. And those are my comments. If you have any questions.
Thanks. Thanks. Jim?
Jim Cinerani, Rhode Island Council 94, American Federation of State Common Municipal Employees. We're proud to represent over 300 law enforcement professionals in different capacities of the state. Out of those 300, though, only 2 groups are actually covered by LEOBOR. Those are my environmental police officers as well as my airport police officers. I'm not going to go and retread all of the testimony. I do think that there is value, and I would just respectfully point out that for a lot of different professions, whether it's the legal profession, whether it's the medical profession, you are generally judged by your conduct by a jury of your peers. It's something that I heard Tony Capezza, who's a mentor of mine with the IBPO, had always said. That said, we are not against compromise. We are well aware that there has been an ongoing dialogue between different law enforcement unions as well as the Chiefs Association, and we're hopeful that some type of compromise can be reached. So in the current form of the legislation, we have to maintain our respectful opposition, but we are hopeful that maybe there will be some type of compromise reached in this session. And with that, I'd be happy to answer any questions.
Any questions for Jim? Thanks. Steve?
Thank you, everybody. Thank you, reps, for hearing my testimony. My name is Steve Alquist with Outrage, Rhode Island. I've been hearing a lot of discussion about the reforming of LEOBOR, but let's face it, reform won't solve the problems. And a few years from now, maybe a decade, maybe less, we'll be back here and we'll be repealing it because we'll be waiting for, let's say, a few more Officer Dolans to shoot a few more kids, or a few more Lugos to punch a few more women's rights advocates, a few more Diaz's to spit on a few more kids in handcuffs, a few more Sergeant Hanleys to kneel on a few more necks, or a few more Kravitzes or Krawitzes to spin kick a few more handcuffed women in the head. These are just a few things that have happened over the last few years, and I'm not saying that all cops are bad or all cops are violent, but there is a problem here, and we are not addressing it. I want to ask you to seriously consider, if we're not going to get rid of LEOBOR, why don't we extend the rights of LEOBOR to every profession, every person who works in the state? Why don't we do that for teachers? Why don't we do it for firefighters? Is there a reason we don't extend these same privileges to all these other careers, all these other places? A group of 3 teachers have to decide and everything that the principal, the parents would be helpless to determine what happens to a teacher who needs to be disciplined. We could do this for firefighters. We could do this for doctors. We could do this for everything. Here, there are professional ways that lawyers can be kicked out of their guild for what happens. They can have their license revoked. But we don't extend this to anyone else. We only extend it to police officers, and that places them, in a sense, in a special position, an above-the-law kind of position that nobody else should occupy. And I think it's kind of a shame. I've covered a lot of things. I've seen an awful lot of police video when police have acted out. I've seen police officers who don't do things that are so bad that they might need to be fired, but they do things that are really terrible nonetheless. I've heard police on their body cameras discussing that they want to go after this person or that person, and then they go over, arrest that person, and claim the person assaulted them because they need a charge. And then those charges are dropped, but they're dropped months later and after a long time. And the people are put through a lot of pain as this is going on. And I think we can hold them to account and I think we can do so, but I also think that we're going to miss an opportunity now if we don't do the smart and reasonable thing, like what is done in most states in this union, in every state but Rhode Island and New England, not have a LEOBOR at all. And thank you for your time.
Thank you, Steve. Okay. The next group of witnesses we're going to call are Michael Tillinghast, Kiana Avlon, and Rabbi Jeffrey Goldnesser. Goldnesser. And is Andrew Mueller here? Andrew Mueller? Okay. All right, guys. Go ahead.
Hello. Hello. First off, I'd like to thank the committee for taking the responsibility to consider whether to repeal or amend LEOBOR. One bill aims to repeal LEOBOR, another repeals the section prohibiting public disclosure, another amends the document to have wording that I'm sure is worded in a way that the new police chief, Oscar Perez, would support. BLM and the NAACP want to repeal LEOBOR entirely. The police chief candidates expressed their support for amending the document. People have certainly expressed discomfort with not having the freedom of press to disclose such incidents. At the same time, officers do not want the public retaliation and humiliation for the bad press. People are innocent until proven guilty. In that language, people are charged with a crime or they're convicted with a crime. At the same time, I believe that these three bills are a step forward towards answering those calls. Repealing the bill, amending the bill, or at least large parts of it would be great. Repealing the section about public disclosure would provide transparency in the face of controversy. Unfortunately, there are not enough officers to publicly dismiss every one. Amending the document to have wording. Oh, wait. Rhode Island taxpayers compensated the officer $120,000 while the officer wasn't actively working, and that should never happen again, especially while so many Rhode Islanders are unemployed. The next part is about the Reform Solitary. I entirely support the Solitary Reform Act, and I would like it to pass immediately without hesitation. The bill can be amended in the future. However, today there are prisoners who can't be here who are experiencing the absence of reasonable regulations behind the walls. I had a friend placed into solitary, a woman from Rhode Island who became homeless in Texas. She was placed into solitary and she was raped, and those officers today experience impunity. Being a law enforcement officer or a correctional officer or any officer of the peace, one should hold themselves to a highest standard. This building is famous for considering conclusive research. There's one famous research experiment that will never be repeated or replicated. That is the Stanford Prison Experiment. That experiment says that any group of uniformed individuals can collectively turn a blind eye to wrongs. That is inappropriate. Please pass the Solitary Reform Act immediately without hesitation in its entirety. Thank you. There's a bill affecting employment post-incarceration. After getting out of prison, people just want to put their past behind them, so I support it. I met a woman who was unable to work to provide for her kids because of her criminal record for some pot. The state was trying to take her kids, and she was forced to work in construction in a dangerous situation where a workplace incident would take her life. An incredible tragedy, and people should be able to put their past behind them. Additionally, people shouldn't have to wait 10 years. A decade of being unable to provide for one's children is cruel and unusual. She wanted me to petition the state to change the laws so she could work to provide for her children. And I wrote letters and spoke to the governor about it. However, it's too late for her. Please remove the post-incarceration work limitations immediately and give my late friend the justice she sought. On 5149, I disagree with the amendments that say some should have the liberty to speak to the parole board and some should not. I've seen major criminals face parole boards, and I'm confident that parole boards can make those decisions on a case-by-case basis. States that don't have the ability to seek parole for life have elderly and ill individuals who have been imprisoned their entire lives, and it's an incredible challenge to be unable to seek parole. And then 6199, I totally support because nobody should fear ICE when they're in prison. Thank you.
Hi, you're up.
Hi, my name is Rabbi Jeff Goldwasser. I'm the spiritual leader of Temple Sinai in Cranston, and I'm a member of the steering committee of the Interfaith Coalition to Reduce Poverty in Rhode Island. I'd like to speak to two of the LEOBOR bills and then also make a few comments about 5 other bills that are before the committee tonight. So I offer this testimony on behalf of the Interfaith Coalition in favor of legislation to repeal or greatly reform the Law Enforcement Officers' Bill of Rights, H. 5567 and H. 6200. With due respect to law enforcement, LEOBOR has proven to be ill-conceived and has served as a shield for wrongdoing. We entrust our law enforcement officers with a great deal of, we entrust them with a great deal of power and authority as the first line of justice in our communities. This is to benefit our entire society. It's exactly what we mean when we say that law enforcement is a public good. Yet we are also warned that the consequences are dire when such power is abused. It threatens our entire society and the foundation of our system of justice. Our shared faith traditions tell us that we must be especially careful to warn those who are entrusted with such power from taking bribes, from perverting justice, and from oppressing the powerless. Unfortunately, this is exactly the opposite of what LEOBOR does. Instead of warning those whom we have entrusted with power against abusing it, LEOBOR protects them from disclosure of their wrongdoing. Instead of making sure that our system of justice deals justly with those who are sworn to uphold the law, LEOBOR prevents swift action when law enforcement officers are accused of wrongdoing. Instead of reassuring communities that law enforcement will work for their benefit, LEOBOR sends a message that the law enforcement officers who illegally harass and disrupt communities, particularly in impoverished communities, will have more protection from being disciplined than the community will have from harassment and disruption. Rhode Island is the only state in New England with a LEOBOR statute. It has resulted in no demonstrable improvement in law enforcement for our citizens. It is time to undo the perverse reversal of the biblical commandment to protect the oppressed. It is time to reform LEOBOR or do away with it entirely. I'd like to also speak on behalf of the Cranston Clergy Association in favor of the Second Look Sentencing Act, H. 6139. This legislation would allow incarcerated individuals who have served at least 10 years of sentence to petition for a reduction of their sentence. In the book of Deuteronomy, our shared religious teaching says, "Justice, justice you shall pursue." In my own Jewish tradition, the sages teach that the word justice is repeated in this verse to teach us that our pursuit of justice itself must be done in a just manner. We need a justice system that is able to judge itself, to notice the ways that it does good and the ways in which it does harm, especially for the most vulnerable in our society. Allowing petition for review of sentences is a positive step towards a justice system capable of questioning itself. I'd like to speak on behalf of the Interfaith Coalition in favor of H. 5149 that would end the sentence of life without parole and give those who are serving a life sentence a parole hearing. That's it. That's all it does. It does not promise release. Rather, it offers that word that is on the flag and the seal of our state, hope. Life without parole is a double sentence. It tells people that we have not only decided that they are unworthy of freedom, it further decrees that they will never be worthy of freedom. That, to me, is beyond our ability as human beings to declare. We cannot know what lies in the future, heart, mind, and spirit of any individual. I sincerely ask you to end the cruelty and hopelessness of this sentence and end life without parole. Similarly, I ask you to support H. 6161 to create a committee to oversee the use of solitary confinement. Solitary confinement is our most coercive and destructive power over inmates in prison. The creation of an oversight committee to monitor the use of solitary confinement is a reasonable and moral method to make sure that when we use this potentially deadly power of the state, we will not allow it to devolve into state-sanctioned torture. I ask for your support for H 5563 to eliminate cash bail for misdemeanors. You probably learned a basic principle of American law that a person is innocent until proven guilty when you were in elementary school. That is where I first learned it. This familiar saying that serves as a basic principle should also serve us in actual practice. Despite this, cash bail for minor offenses is a real and present form of punishment for people without evidence or due process, especially if the accused is a person living in poverty. Cash bail is inherently discriminatory against people who do not have the ability to pay. Cash bail treats those individuals as guilty before trial by forcing their detention before they've even had a chance to make their case. This is why a number of states have done away with cash bail for misdemeanors. And finally, I ask you to support a very simple, common sense piece of legislation, H 536, that would reconcile Rhode Island's definition of a misdemeanor with federal law to prevent the deportation of individuals for minor offenses. By changing a misdemeanor from an offense punishable by up to a year in prison to 364 days, a difference of 1 day, we can end the agonizing fear of non-citizens that they could be deported for an offense as light as public intoxication. I thank you very much for your time and for the privilege of addressing these important issues before this committee.
Thank you, Reverend. Okay, the next group of people are going to testify, which I think is the last group for these bills. Kiana Avalon, David Velez from the Rhode Island Interfaith Coalition, Andrew Mueller, and we haven't got, how about Bella Robinson? Is she here? Okay. And Claire Hardy.
Thank you, Chair and committee members. Should I testify really quickly for all of the bills or just LEOBOR?
Yeah.
Might as well do it, right? Thank you for having me. David Valise, Director, Rhode Island Interfaith Coalition to Reduce Poverty. We are a coalition of faith leaders throughout Rhode Island that are dedicated to fighting inequality and poverty. I'm just going to run through the numbers and just give a quick sentence. We are here to support several bills. First, 5149. We do believe in eliminated life without parole. As Rabbi Goldwasser just mentioned, we think it's immoral to determine that someone has no chance of redemption, a quality that is rooted in a lot of our faith traditions. We also support 5361,